Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning, everybody. Yes, it's Ada K here. Yes, it's Casual Friday here. Yes, I'm one tired cup. Oh my gosh. I'll share with y'all later about the concert. I couldn't find my baseball cap. How are y'all doing? I hope you had a good night. Welcome one sunny day. June, welcome. Thank y'all for liking. I got extra. Give the first 3 people extra points for entries. Yay! My hair is an absolute volatile mess. But it held some curl. It held the curl. Go figure. Okay, guys, today we're going to be diving back into the Monica Sementilli trial. We are on day 25. Yes, 25. And for those of you who don't know, who may be new, Monica Sementilli is accused of unaliving her husband, Fabio, because she allegedly wanted to continue her XXX rated love affair with a new man and collect $1.6 million in life insurance policy. Total assets of his estate was almost $2.5 million. Fabio Sementilli was found bludgeoned to death inside their Woodland Hills home back in January of 2017. Monica and her lover, Robert Baker, were arrested 6 months after the crime. Monica Sementilli is charged with redrum and conspiracy. Baker pled no contest to the charges and is getting life in prison. Christopher Austin, who was with Baker at that time, is also facing charges. He has been testifying for 3 full days. I think they're going to close up his testimony this afternoon. Well, that doesn't help much. I left my other glasses in the car. Oh, snap it. But, yeah, that's almost worse. I can't wait to get my glasses fixed, y'all. Oh, it sucks not having my glasses. But anyway, we have had, I don't understand why this poor guy has been on the stage, so to speak. Oh, see if I can wear these. I got to find this sweet spot. See if I can wear these without the nose piece today. I've been going without my glasses for 4 days now, and it's not fun. And these are progressive bifocals. I'm pushing trifocal here. Good morning. Good morning, Dawn. Good morning, one sunny day. Yes, June. Good morning, Jesse. Good morning. It was fabulous. I am not used to going to a concert as a viewer of a concert. I'm used to going, um, and working a concert, interpreting it, that kinda stuff, and it was interesting. I did sign all night long, but, I have a story to tell about my interpreting people, but that said, we had, she's a fabulous performer. CeCe Winan is who I went and saw, and CeCe Winan will she performed the entire time, song after song. She did talk some, but, I mean, she's just a dynamic performer in general. You just can't beat her quality of performance. And it was different. It wasn't like just a rock concert. It was if you're Christian, you understand what I mean when I say it was worship. It was worship, and that is, awesome. I danced, I signed, I took my dog with me. She did a fabulous time. Let me see if I can share this. I have some video, but because of copyright, I can't share it. I can't share. Let me get I don't wanna leave studio. I wanna present, share screen. There we go. For those of you who don't know, this here is CeCe Winans. Stop it, Sensei. You're fine. CeCe Winan has been around since 1985. Well, she grew up singing with the family called the Winans and, gospel, and then, she grew up with, I thought this would go to the next picture. Yeah, I'll just have to open them individually. I'm so tired of this everything opening up in Canva. I gotta figure out how to do that, get rid of that. Everything I have opens in Canva. But anyway, she's a classy lady. Let me do this. And it won't share it. This was her second outfit. I don't need to show all the photos. I didn't take a ton of photos, but I took a lot. Took about 10. Oops. She's just a classy lady. Thoroughly enjoyed her. So anyway, like I said, I got about 9 or 10 photos and the rest were about 4 or 5 videos. But I have a story to tell. When I was going to college to get my degree as a deaf support specialist, and well, actually, I went to get a degree in interpreting. I was at the beginning stages of my deafness, and I had a lot of people who were not very. I was also in a wheelchair throughout that entire time because the rheumatoid arthritis was out of control, and yeah, it is, Jess, I gotta figure out how to change that. So, what ended up happening is I had teachers who were not nice and felt that because I was disabled and in a wheelchair and losing my hearing, I should not be in the interpreting program, and it was made very clear that if you had a learning disability, you had certain disabilities, they would push you into being what's called a deaf support specialist and not an interpreter because they felt that you have to be flawless to be an interpreter. So, discriminating much? It got to the point that the department head and her teachers, not all of them, but most of them, refused to give me any of my accommodations that I use for dyslexia because they said the English proficiency exam that we have to take before becoming an interpreter does not accommodate, and they do not accommodate for taking the exam for becoming a certified interpreter. Long story short, um yeah, they do. Yep, they do. And, the departments I ended up hiring an attorney. Yeah, I did. And, the ADA attorneys of Texas, I didn't have to pay for them, but they were hired. Took 3 years of fighting before I finally, in my last semester, got accommodations for my dyslexia, and they were mad because I asked for an interpreter for my classes, and I said, "Look, when the teacher turns away and is speaking in English and they turn away, I lose 'em." Now in the other classes that were all sign language classes only, I didn't have a problem. And I said, "How can a a hearing person who claims to be deaf be an interpreter and need an interpreter?" Well, that's a good question, but this school and this department is the number 1 in the nation, schools, one of them, for American Sign Language interpreting training, and they, um, do have what's called a certified deaf interpreter for the deaf. Well, I could have done that, but anyway, long story short, the department got their hands royally smacked by the American disability lawyers, and so they don't like me over there, and I'm like, "Look, I have to fight for myself, I will," and I did, and one of the teachers there who absolutely hated me was at the concert. Some of the people that I was in class with is at the concert. So 8 years ago, I graduated, and I coulda sat with them, but when I have a $100 front row dead center ticket, I sat in my seat and watched the interpreter when Cece was talking because I couldn't understand her, and they have 2 interpreters, so they would rotate who was interpreting, they'd switch, and they were watching me like a hawk, and I felt so uncomfortable, so uncomfortable. So, um, there is a huge difference between interpreting signing and conversational signing and also what is called worship signing. When I'm signing in worship, I'm not paying too much attention to grammatical. I'm worshiping, and it was so uncomfortable when I was signing. I signed all night long. Finally, I just felt in my spirit that, "You know what? Bitch," I heard my sister, which was another I heard my sister's voice, "Bitch, please, you worship, forget about them." Yeah, a department that teaches ADA compliancy and teaches you all the ins and out of the law and all of that breaking ADA law. Yeah, prejudice much, um, and one of the things I used to tell them, "Look, I have a reason. I am 55 years old. I know what I want. I'm not a 19 kid who has no idea about life, and I'm like, look, I've got wisdom. I know that even today, I don't take a job that I know is above my capabilities or would be affected by the hearing issues I have. And when I do interpretation, I have major sound system in my ears that magnify the sound that my son standing 10 feet away from me can hear noise coming out of my hearing aids. Jesse, I will never interpret rap. I don't like rap, and that's not my thing. It's about the only thing I don't interpret, hard rock and rap. I interpret anything else. But anyway, you know, it's amazing how words can affect somebody and think you've gotten over it, you think everything's fine, you've moved on with your life, you run into the people that said those mean and hateful, nasty words, talked about you behind your back, accused you of lying about being disabled and deaf, all of those things are running back when you run into them even 8 years later. Um, it it's amazing, but I thoroughly enjoyed the concert, uh, to sit and enjoy the feeling of being watched like a hawk, like I was. Um, but you know what? If you guys are watching this live, screw you. Grow up. So, anyway, I met some very sweet, sweet people, and I did get signature on a VIP, and then I got a poster with her signature, so, um, definitely enjoyed the concert. Would go to hers again anytime, anytime. Oh, the interpreter, yeah. Those are a special breed, y'all. They really are. There's one interpreter that I used to follow, and I loved her, and she faced similar discrimination from this department, and she went on to become very famous for her interpreting rap, and she became very famous in, what's called, musical interpreting or theatrical interpreting, and, now they have her come in and speak. It's kind of interesting how that turned around. But anyway, um, it just goes to show that sometimes old wounds can be opened up. And then I kinda got emotional because I had bought tickets for my sister and I to go. I both of us thought she would be here, and, um, I wore her shirt, her thing. Hi, Elena, welcome. Yes, I did. Um, but I found myself crying at certain points because I miss her, and she and I would have been signing together and enjoying CC Winan beyond all measures, and it was hard to sit there and not have her with me. I think that's the first big thing I've been to without her. So, I don't wanna cry. Anyway, um, she's just
Sementilli,
it was
defendant's
just
present, all
a
counsel
great
present, jury, and also present. Good
time,
morning. Thank
and
you,
all those people
Mr.
who were
Donuts.
being asses
I had the largest fight of my life a little while ago. I
get what you
opened the box
deserve.
just to look,
I find it
and every one of
interesting
them
that
called my name.
people can go to
Literally
church
called my name.
and
I
then
had to say
turn
no.
around and be such jerks in the public world.
Jack Ferrell, please take the
Hypocrisy.
stand. You're still on the road.
And
And you may inquire.
let me get this lined up.
A little while ago.
So, let me turn this off. I have that on. I don't know if I need it on, but, I kept hearing my sister, and I finally got to where I ignored them, and it was a fabulous night, and if you ever get a chance to see a CeCe Winans in concert, she's fabulous.
I opened the box just to look, and every one of them called my name. Literally called my name. I had to say no. Jack Ferrell, please take the stand. You're still on the road.
What is he talking about?
And you may inquire. Thank you, Esther, with the donuts. I had the largest fight of my life a little while ago. I opened the box just to look, and every one of them called my name, literally called my name. I had to say
About
no.
a dozen donuts.
Jack Ferrero, please take the stand. You're still under oath.
I need to get some stuff. Oh,
And you may inquire.
I've never been impacted this much by grief, and I've lost a parent. I'm gonna, while we get started, I'm gonna rinse out the coffee cup. My feet are too cold. I gotta get socks on. I'll be right back.
Dr. Farrell, when we left off yesterday, we were talking about the large-scale operation you and your partner set up to take place in Vancouver, Washington regarding Christopher Austin.
Correct.
With respect to what's been referred to in this court as Perkins operations, where a suspect is placed into a jail cell with an undercover agent posing as an inmate, is that procedure used solely on homicide cases and maybe some violent crime?
Yes, it's used exclusively, or it's restricted for homicide or serious violent felonies.
Okay. So it's not something that takes place every day.
Correct.
And within robbery homicide division, we heard that there are different sections, such as the homicide section, as well as the surveillance section. We've heard from SIS. There's also, as you mentioned yesterday, I believe, individuals who are responsible for the planning, coordination, and execution of all Perkins operations that occur within the city of Los Angeles.
Correct.
And those detectives also travel out of state in order to assist detectives such as yourself and Detective Byers on cases that originate from LA County, but where suspects are out of state. Is that correct?
Yes.
Okay. And sometimes also assist detectives from other jurisdictions that might come into the city?
Yes, they do.
Okay. And there is an entire set of protocols that apply to those operations, correct?
Correct.
And so you brought those individuals with you when you went up with your team to arrest Mr. Austin and to conduct a Perkins operation, correct?
Yes, they helped facilitate the Perkins operation in Vancouver, Washington.
Okay. And I believe you told us yesterday that you and your partner coordinated before you flew out with the team to Vancouver, Washington with the Vancouver Police Department.
Correct.
Given that it wasn't your jurisdiction.
Correct.
Okay. And so when did you and your partner and your team fly out to Vancouver, Washington?
It was at the beginning of October. We flew out before the actual operation to set things up, to brief the Vancouver Police Department, and to make sure that the operation was set to move forward on October 2nd.
And whenever there is a Perkins operation, there's always a briefing that takes place so that everybody understands what their roles are, correct?
Yes, the Perkins briefing is separate. The general briefing, which would establish what everybody's role was in the arrest and subsequent search warrants and additional interviews that were done in accordance with the operation in Vancouver, Washington.
Okay. And so when you said that you and your team flew out the beginning of October, that would be beginning of October of this past year, 2024, correct?
Correct, 2024.
All right. And when you mentioned search warrants, was there also a team of detectives that was tasked with serving a search warrant at Mr. Austin's home?
Yes,
And during that warrant were various electronic items recovered, such as computers, hard drives, cell phones, things of that nature that might contain data.
yes,
And did you also recover Mr. Austin's main cell phone, not his work cell phone for the probation and parole department for the state of Oregon, but his personal cell?
yes.
And was that relative to a phone number 907-306-7486?
Correct.
And I believe.
Did we just get that entire phone number? We're not supposed to get the entire phone number, y'all. Thank you, guys. I appreciate you.
Celebrate extraction for that cell phone. As maybe it's a cigars. That was marked as, yes, for this exact phone number as exhibit 244. And during this procedure, was a team also tasked with interviewing his wife, Chloe?
Yes,
And was Mr. Austin then arrested on October 2nd of 2024 by the Vancouver Police Department in conjunction with your operation?
he was.
All right. Now, it's been brought out through Mr. Austin as to what he recalls occurring, but from your side of it, is there something that happens at the beginning of a Perkins operation or at some point during a Perkins operation once the target is placed inside of a cell?
Yes.
And what is that?
So detectives, one of the detectives, if not both, depending on the circumstances, will come and provide information to the arrestee in order to try and elicit a conversation between the Perkins agent and the arrestee. And so because the assumption is that the Perkins agent is in the cell and does not know any information about the arrestee's arrest, so by introducing information, it potentially could spark a conversation about the case.
Okay. And that's referred to sometimes, I think we've heard as
Sorry.
stimulation?
Yes.
Okay. When the stimulation, the first round of stimulation was done after Mr. Austin was placed into a cell in Vancouver Police Department's jurisdiction, was the Perkins agent or the undercover agent already in the cell when the stimulation was done?
I believe so.
And was that stimulation where you come to the cell door and provide information, was that done by you?
Yes. And yes, he was in the cell. I misunderstood your question. He was already in the cell.
Okay. And did you explain to Mr. Austin in front of the undercover cellmate that you wanted to know, with respect to the murder of Fabio Sementilli, what everybody's role was who was involved in the operation?
Sorry.
Correct. I introduced myself as a detective from the Los Angeles Police Department, made him aware that he was being detained for a warrant from Los Angeles, And I did explain that our goal was to speak with him so that we could obtain information as to everyone's role in the murder of Fabio Sementilli.
And at that time, did you also tell him that you and your partner wanted him to be honest?
I did.
At any point in time, did you use the name of Monica or Monica Sementilli when you were conducting your stimulation at the cell door?
I did not.
At that point, did you leave Mr. Austin in the cell at Vancouver Police Department with the undercover inmate?
I did.
Okay. And when this is set up, is there a recording device inside of the cell?
Yes.
And does it allow you and anyone else who is monitoring the situation, such as the detectives who run these Perkins operations for the city, are they able to listen simultaneously to any conversation that might occur?
Yes.
And at that point in time, were there hours and hours of silence from Mr. Austin?
Initially, there was silence from Mr. Austin, yes.
Okay. At some point in time, did you go back to the cell containing Mr. Austin and the undercover agent posing as an inmate and again attempt to provide information to Mr. Austin in front of the cellmate to provide a potential stimulation?
I did.
Okay. And at that
I gotta
point,
get
did
my
you
other
show
glasses.
him certain photographs?
I did.
And what were those photographs of?
I showed him a still photograph of the surveillance photo, which shows the two joggers coming up to the Sementilli residence. I also showed him a photograph of the Porsche. It's a still photograph from the surveillance video of the Porsche leaving the residence after the murder.
And did you, at the same time, explain to Mr. Austin that you and your partner knew how he got to the crime scene and left from the crime scene, but you wanted to talk about the part in between?
Correct.
All right. And again, did you stress to Mr. Austin that you wanted him to be honest with you?
Yes.
All right. And at that point, did you once again leave him in the cell?
Yes.
And throughout that day, did you and your partner, as we heard from Mr. Austin, have various conversations with Mr. Austin after you removed him from the cell and then would place him back in with the undercover agent?
Yes.
Okay. Now, at some point after that day, did you and your partner cause documentation to be filed for the extradition of Mr. Austin to LA County to face charges?
Yes.
Okay. And after that, did you and your partner, as well as the team from LAPD's Robbery Homicide Division, return to Los Angeles?
We did.
Okay. And at some point after that, was Mr. Austin indeed extradited to LA County?
He was.
All right. Through the normal procedures. Is that right?
Correct.
At in November of 2024, beginning on November 18th, did you and your partner sit down with Mr. Austin at the Robbery Homicide Division?
Yes, we participated in a proffer session.
What is a proffer session?
It's facilitated by your office, by yourself and Ms. Stagel, in which, and Mr. Austin is represented by his attorney. And it's a situation where Mr. Austin is asked to provide all of the truthful information he knows about the case in a formal setting.
Okay. And is that a setting where there is a court reporter present who transcribes what's being said, as well as a recording
Yes,
created, an audio recording.
yes,
Okay. And did that continue after the date of November 18th to another date 2 days later on November 20th, again at the Robbery Homicide Division?
yes, it did.
And did you and your partner cause Mr. Austin to be removed from the LA County jails in order to be brought out to Robbery Homicide Division to conduct those interviews?
We did.
Now, during the recounting of what occurred after Mr. Austin flew into LAX on January 22nd of 2017, the day before the murder of Mr. Sementilli, did Mr. Austin begin describing going to a restaurant?
He did.
And did he describe that this restaurant was a restaurant that he did not know the name?
Correct.
And did he describe the location?
He did.
Did he describe the location as being in an L-shaped strip mall?
Yes,
And did he also describe the location as there being pillars, much as he described here in court during his testimony?
he did.
Did he also describe to you and Detective Byers, as well as to myself and Ms. Stagel, that there was a parking lot, a large parking lot behind the strip mall?
He did.
Did he also describe various or mention various types of businesses that were located in the mall at that time in 2017?
He did.
We're going to object to the leading.
Those are the questions we're not leading.
Did he do so?
He did. He described the nail salon. He described the pillars. He described the L shape, described the parking lot in the back.
Did he also mention anything regarding a restaurant or a food place?
He did. He mentioned a Chinese restaurant.
Okay. Did he also describe anything regarding a postal or mail service in the location?
I believe he mentioned a UPS store.
And was he not only unaware of where the location was, other than it being in the San Fernando Valley, but did he also tell you whether or not he knew the address of the location?
Objection, compound, and cluster speculation.
Overruled.
He did not provide the address of the location. He didn't know. He only provided a physical description.
At the point in time where he was describing what had occurred on the night of January 22nd of 2017 and this location, had you ever heard any information relating to this before?
No, this was the first time through my examination of the prior investigations as well as our investigation that we had any information that any event of significance had occurred the day before the murder on the 22nd. It was Mr. Austin who drew our attention to it.
So did any of the investigative materials contained in this case mention anything regarding an attempted hit on Mr. Sementilli the night prior to his murder?
Not until that day in the proffer with Mr. Austin.
At some point in time, as Mr. Austin was describing the location, did he mention anything about a nearby grocery store?
He did.
Did he know the name of the grocery store?
He did not. He said a grocery store.
And contrary to what was asked, stated by defense counsel yesterday, was he asked what store was nearby?
Nor object, argument.
Sustained.
Was he asked when he mentioned a store, what store was?
When he mentioned grocery store, there was an attempt to identify which grocery store chain he was referring to, but he was unsure as to which grocery store it was.
And was he, even before we got to the fact of it being a grocery store, did he simply mention that it was in close proximity to a store?
Objection states the evidence.
Still rule.
Yes,
And did he indicate that the store was not too far from Mr. Baker's home?
yes,
When he was asked what type of store, whether it was a drugstore, a supermarket, or other type of store, at that point, did Mr. Austin indicate, in fact, that it was a grocery?
I forgot to tell you. Crosby is allowed to testify in the Karen Reed trial as an expert. Crosby is allowed to testify as an expert in the Karen Reed trial. Auntie Bev wrote one paragraph giving her explanation as to why he can. She wrote multiple pages on Dr. Russell. And there is definitely, in my opinion, clear signs of favoritism in this trial. And she should recuse herself. And do you know what? Not only do I say that, but a lot of lawyers are starting to say, this document, when you compare this one with the Dr. Russell's, you can tell beyond no reasonable doubt that this woman is pissed off at the defense and favoring the prosecution. And if that's how I feel, that's how I feel. Back to the Sementilli.
Grocery store, as you've made, just said.
yes. When pressed, he said grocery store.
And at that point, did Mr. Austin ask the group what type of, or what grocery stores were popular in the San Fernando Valley area or here in California?
Yes,
And did he mention that Ralph's is popular in California?
I think someone mentioned Ralph's, but I'm not sure if it was Mr. Austin or not.
And then did Mr. Austin ask, as opposed to stating it was a Ralph's, that the question of, is it a Ralph's?
I believe so.
Okay. And at that point, did he say it was a grocery store, given that he didn't know the name?
Objection calls for speculation as he didn't know the name.
Sustained.
Did the witness, Mr. Austin, state, but it was a grocery store
Yes,
without giving any name?
correct. He was unsure of the name or the grocery store name.
At that point in time, was a break taken from the interview process?
Yes,
And then outside of his presence, was there then a search on a computer to try and identify the location that Mr. Austin was describing that was not too far from Mr. Baker's apartment?
yes,
Was there also a search at that point in time on a computer at Robbery Homicide Division of the defendants and the victims' cell phone extractions?
yes,
And was the search specific to whether or not there were any communications relating to a restaurant or food matching up to the date of January 22nd of
Yes,
2017. And at that point in time, did you note that there were deleted searches on the defendant's cell extraction from her Apple cell phone number 119 for faux restaurants or pho restaurants between the time of 5:12 to 5:15 p.m.?
yes,
And did you note specifically that although the defendant went back and deleted those searches, that they remained from the data that was able to be carved out from the cell phone extraction?
yes,
Overruled.
During that same period, or just after that period of time, again, from the deleted portions of the messages on the defendant's cell phone at 5:41 p.m., did the defendant send an instant message to somebody regarding
yes,
fried rice or
Yes.
some specific type of food?
yes.
What was that?
She sent a message to her daughter Isabella asking if she wanted fried rice for dinner.
And just after 5:41, at 5:45 p.m. to 5:47 p.m., again, from the deleted portion of the phone, did the defendant conduct some Google searches?
Yes,
And what did those relate to?
to pho restaurants near her location. Specifically, it provided an address of 19548 Ventura Boulevard, Pho, California, or Pho, CA.
Okay. And were there similar, or was there a search for pho near me or pho near me on the victim's cell phone just before that time as well?
Yes,
Once you were able to obtain that information regarding a search of a particular pho restaurant on Ventura Boulevard, did you then also search, along with the group that heard this information, various, or that particular address of that pho CA or pho California?
yes. I conducted a Google map search, which shows both a street view and an aerial view of the 19548 Ventura Boulevard, where the Pho California restaurant was located. And I noticed that it had a parking lot in the rear, that it had pillars inside the strip mall, that there was a nail salon inside the strip mall, and that it could be perceived that it was an L or a U-shaped strip mall.
And was that location approximately 4 miles from the Queen Victoria residence where the victim and the defendant were living?
Yes,
And then did you print out those photographs?
yes,
And at that point, were those photographs that we've seen here in court presented to Mr. Austin?
they were.
Your Honor, I have a 10-page timeline from the defendant's iPhone extraction for the date of January 22nd of 2017 that shows these particular searches as well as the deletions history. May it be marked, please, as people's next in order.
That'd be 259.
Thank you. swap that one. This one's 9 pages, right? I'm gonna swap out the one that's not. Showing you the Celebrite report. For the defendant's Apple iPhone. Is this the extraction that you looked at for January 22nd of 2017?
Yes,
And if we look over at the right column, what does this column represent? Where it says yes in red.
that the information attached to that particular line had been recovered from a deleted area.
If I go to the third page, where there's a line 24, what do we see here at 5:12 p.m.?
See a message, incoming message, instant message from a person that she's identified as daddy, and I believe that to be the cell phone associated with Fabio Sementilli, to her cell phone number. It's listed as Monica owner, and the Google search for "fa" near me.
Subsequent to that, are there searches on the web, through the web history on this device, as we talked about, beginning at 5:12 p.m., for Google searches near me?
Yes,
And then below that, again, at 5:13 p.m. on January 22nd, do we see a search specific to this location, faux CA or faux California, as you mentioned?
yes,
And over to the right, again, does it indicate that
Thank you,
these
beloved.
searches
You were
were
so kind.
deleted from
Thank you
the
so very
defendant's
much.
cell phone,
I love and appreciate that.
yes,
You
but
have
were
no
recovered
idea.
during the Celebrite extraction?
correct.
And looking at the following page, page 4, again, do we see multiple searches relating to this same location where the address comes up on line 32 that you just testified about, 19548 Ventura Boulevard?
Correct.
Showing you what's been previously marked as People's 249. Is this one of the photographs that you printed out the date of Mr. Austin's initial interview at Robbery Homicide Division based on identifying the location?
Yes,
And does this document in fact contain his circle around a location in the parking lot?
yes,
The next page of People's 249, second page, is this again a photograph that you printed out from a computer at Robbery Homicide?
yes,
And another one here in the third and fourth page, and fourth being an aerial of the location
yes,
with again Mr. Austin's writing.
yes,
And once again, if we look at the second page, did this particular strip mall also contain a UPS store as described by Mr. Austin?
yes.
relating to the defendant, Robert Baker, and the victim?
Yes, he was.
Now, during the trial on February 26th, did you and some other detectives plan in order to take Mr. Austin once again out of the jail facility pursuant to a court order to the location where he crossed through a tunnel at Oakdale near the Sementilli residence and describe where he buried the knife?
Yes,
Also, during the Proffer session in November of last year, when Mr. Austin described a tunnel that he crossed through, once again, was a search conducted during a break on a computer at Robbery Homicide Division for a tunnel near the location of the Sementilli residence,
yes,
and showing you what's been previously marked as Exhibit 250 or Exhibit 10 from the proffer. Was this photograph shown to Mr. Austin?
it was.
And did he identify this as the tunnel that he used when he was running from the crime scene prior to being picked up by Mr. Baker?
He said it looked like the tunnel, yes.
And so did you take Mr. Austin out to this location on February 26th?
We did.
And at that point in time, did you have him trace his path?
We did, yes.
And was he able to identify the Sementilli residence as the location where he and Mr. Baker jogged up after he came out of the trunk of the rental car in order to conduct the murder?
Yes, he recognized the residence on that date.
Was he able to identify the location or the specific area where he believed he had buried the knife that was utilized during this murder?
He was not able to identify the specific area.
And did he tell you why that was?
The neighborhood had changed.
Overruled.
Sorry, the neighborhood had changed dramatically since 2017 when the knife was buried.
And did you determine that that was accurate based on pictures of the area in 2017 versus today?
Yes, when I went back and looked at archived photos through Google Street View, which archives years of changes on the Street View, I noticed that several landscapings of the residences in and around the area, as well as the facade and residences themselves, had changed since 2017.
There were a couple of defense videos of the victim and the defendant dancing and singing that were played during this trial. Did you obtain, you and your partner, those videos from Jessica Sementilli after her testimony in this case?
We did.
And did she also send you photographs of metadata for those two videos?
She did. She provided a screenshot which showed the date that the video that she had attached to those videos.
And was one of those dated October 31st, Halloween of 2016?
Yes, the video that shows the defendant and Fabio Sementilli dancing was from October 31st of 2016, I believe.
And what about the one of them singing where they appeared to have some kind of animation applied with hats or something of that nature?
Yes, I believe the date of that video was December 3rd of 2016.
Okay, thank you. I have nothing further.
Mr. Burke?
Thank you. morning, Detective Farrell.
Good morning, ma'am.
Detective, when first you assumed responsibility as one of two primary detectives on the investigation in this case in June of 2024,
Correct.
correct? About 7.5 years after the killing of Fabio Sementilli.
Yes.
And I think you spoke yesterday and today specifically about information you reviewed when you came into the case about one of the suspects in the case, Christopher Austin, who was already a suspect at the time you came in?
Correct.
Okay. And I think you testified that at the time you came into the case, he was one of the two suspects who had been identified, in fact, right around the time that Mr. Sementilli was killed. Is that right?
I don't know about identified, but he definitely was suspect as being the second jogger in the video participant in the murder of Fabio Sementilli.
Okay. When, in your review of the original investigation, when did Christopher Austin's name first come up?
I don't remember the exact date.
Would it be fair to say sometime in the late winter or spring of 2017?
I don't remember, ma'am. I don't remember when his name came on the radar.
Okay. When was the first investigative material that you reviewed in the case created that discussed Christopher Austin?
Honestly, I don't remember. I remember reviewing the material, but not necessarily the dates. If you'd like to refresh my recollection, I don't know what date he became a suspect in the case.
Well, as part of your work in the case, I assume you reviewed the chronology, the murder book, the investigative details of the original investigation?
Certainly. I mean, this was 7.5 years worth of work with 3 prior sets of detectives. And, so there was a tremendous, as you know, volume of information.
Okay.
So I don't
And-
remember the exact dates. I do remember information pertinent to what our goal at the time was, which was to effect an arrest of Mr. Austin.
Okay. And it would be fair to say, as part of that goal to effect an arrest of Mr. Austin, you reviewed anything in the investigative file that had been discovered related to Mr. Austin.
Yes.
And what material in the investigative file did you specifically
Hello,
review
Henley
related
Mouth.
to Mr. Austin?
So there was, obviously, we started with the jogger video. There were cell phone records associated with Mr. Austin. There was an identified burner phone that was believed to have belonged to Mr. Austin. There was cell phone mapping, which suggested the burner phone belonged to Mr. Austin. There was, prior to us,
I'm sorry. I'm sorry. I think it will be more efficient if we can talk about each item as he, yeah.
Open-ended question. And
I
we'll be allowed to
apologize.
finish his answer.
so there were also airline records, which showed Mr. Austin in and around the Los Angeles area at the time of the murder. There was additional cell phone information, which suggested Mr. Baker had contacted Mr. Austin at the time his flight arrived. There was additional cell phone information that suggested that Mr. Baker had, as we heard yesterday, dropped Mr. Austin's pin at the flyaway bus. There was information that Mr. Austin had made a purchase of a ticket at the flyaway bus. There was information from the airline records that Mr. Austin had changed his flight so that he left, in my approximation, 6 hours after the murder, which was highly suspicious to us. There was a tremendous amount of things that we reviewed. There was DNA evidence that was recovered, and Detective Roberts had asked Vancouver PD to get a surreptitious sample, and that was examined and inconclusive. So there was a number of things that were reviewed.
Thanks for asking, Elena.
Okay, thank you for that. Let's go through those. And do you have any portion of your investigative file or chronology with you today?
I do not.
When you mentioned that we had these items, are you saying that you had those items at the time that you came into the case in June of 2024?
Yes, most of those items had been obtained, analyzed, and had been deciphered at that point. Yes.
The extraction from the cell phones of Mr. Baker, that is something you reviewed when you came into the case, correct?
Yes.
And that extraction demonstrated to you, when was that extraction taken?
I believe there were several extractions done on that phone.
Okay.
The most recent being in June of 2023, I believe.
Okay. And the first extraction of that phone was back in 2017?
Yes.
Okay. And that's something you reviewed?
I'm sure I did. Again, I reviewed, as you know, there's thousands, if not tens of thousands of documents and electronic files. So yes, in the 4 months prior to the arrest of Mr. Austin, we did our best to review as much as we could of the evidence.
Isn't it a fact that in the extraction that was performed in 2017, after Mr. Baker's phone was seized at the time, on the day he was arrested from his apartment, there was an extraction that reflected communications with Christopher Austin?
I don't remember that. There may have been.
Okay. And isn't it a fact that the surreptitious taking an operation to retrieve Mr. Austin's DNA occurred when Mr. Austin was still living in Alaska, well before you came into the case?
No, I believe that was in Vancouver, Washington, and was done by detectives from the Vancouver Police Department.
When was that?
I don't remember what year that was done.
But before you came into the case?
Before we came into the case, but I'm certain that it was done by the Vancouver Police Department.
And am I correct, Detective? It was also the case that back in 2017, the investigators determined that Mr. Baker had, the day before the murder, gone to the airport, the LAX airport, and in the early morning hours of January 22nd, 2017.
I don't know if that information was available to them.
You didn't review that information?
I don't
when you
remember
came-
seeing that information.
Detective Farrell, when you began your investigation in June of 2024, you were a significant part of your focus was on Christopher Austin?
Yes.
And you shared with us yesterday that you, as part of your investigative work, you reviewed bank records.
Your arms are getting on my nerves already.
From First Credit Union in Anchorage, Alaska.
Yes, in relation to the purchase of the tickets.
And when were those bank records? Did you make application to get those bank records?
No,
Who did?
the investigators prior to my arrival on the team.
Detective Roberts?
I'm not certain.
Was it someone back before Detective Roberts?
I don't know.
So you did review those records, correct?
In relation to the plane, the flight purchase information, yes.
And those records were obtained by search warrant?
I don't know.
You don't know whether they were obtained by search
They
warrant?
may have been by court order or subpoena. I don't know how they were obtained.
Before my time, boo. Before my time.
Okay. But when you assumed responsibility for this investigation and were focused on Christopher Austin, you immediately reviewed everything that had been done investigatively on Mr. Austin, correct?
Yes, but we focused on the evidentiary items which suggested Mr. Austin's involvement in this murder.
Okay. Did you feel when you reviewed that in June of 2017 that you had enough evidence to go out and have a probable cause warrant issued by a judge for Mr. Austin's arrest?
The same.
Did you make any attempt in June of 2024 to obtain a probable cause warrant for Mr. Austin's arrest?
Not in June, but later, obviously in October we did.
Right. We're not talking about October. We're talking about June. Is there any reason you didn't make application for a probable cause warrant for Mr. Austin's arrest in June of 2024?
We had written new search warrants for the airline records. And we were working with Vancouver to see if the effect of the arrest was even a possibility. We had to determine whether the Perkins operation could be run in Washington. Those things took time.
So you contacted Vancouver in June of 2017 to start making arrangements?
Roughly.
When you say roughly, was it?
I mean, it might have, we might have gathered the information, learned more about the case, and it may have been in July. I'm not sure if it was June or July. But when we knew that we wanted to proceed against Mr. Austin, we contacted Vancouver PD.
Okay. And when did you first contact Vancouver PD?
Near the beginning of our investigation, our portion of the investigation.
And it would be fair to say that was June?
June or July, somewhere in there.
Okay. And when did you first run the database that you testified about yesterday to search for any traffic citations or any database that allowed you to discover the citation that Mr. Austin received back on January 23rd, 2017?
Sometime in September, I think.
So you decided to start the process for arresting Mr. Austin in June of 2024 by contacting that month or the month after Vancouver and speaking to your Perkins team, but you didn't do the search on the database till September of 2024?
So ruled.
Correct.
I'll be right back.
Detective, did you feel as a over 2-decade detective in robbery homicide that the search of the database and discovery of that citation was a significant and essential component of your probable cause determination to get an arrest warrant for Mr. Austin?
I wouldn't say it's significant. It was a portion. I mean, there was a number of other elements that suggested probable cause was present to arrest Mr. Austin before the citation was, but it was significant.
You just said there was a number of other elements that was probable cause to arrest Mr. Austin before you got the citation. When did you have those elements before you got the citation?
Some of them we had when we assumed the investigation. As I mentioned, new warrants were generated for the airline travel. So we waited for those to be returned to ensure that the information was correct on that, as well as to determine if there were additional flights that had been missed with other carriers. So, I mean, that was something that took some time.
Okay, so you said some of the elements of sufficient probable cause you had before you took over the investigation, correct?
Some,
Okay, which were those?
well, I mean, his physical appearance was one element that was documented in the probable cause warrant.
Okay,
That was one that was known to us.
okay,
We actually had some phone analysis done on his personal phone, which was known to him, as well as the burner phone, to examine whether the two phones appeared to be connected in any way. So that was something that we generated at a later time. So
okay.
the phone numbers were known.
I apologize for interrupting. Why don't we talk about, my question was before.
Again, Your Honor, I'm going to ask the witness be allowed to answer
You
this
did ask
question.
some
She
other
asked the
questions.
question.
You may finish.
Objection non-responsive,
That's
as to the
overruled.
latter part.
That is not.
Okay.
The information, so the information you're asking about is before?
Yes,
So the
sir.
information that the burner phone that was associated with Robert Baker had made numerous calls to this other burner phone, which was eventually established to belong to Mr. Austin. That information was known to us before.
Okay,
We had information about the airline tickets, which was known to us before,
okay,
that he traveled to Los Angeles. I believe that the information about Baker going to the airport in and around the time the flight arrived was known to us. And his departure from the flyaway, I believe, was known to us as well.
okay. And what were the elements of probable cause that you felt were sufficient that you gathered after the time in June of 2024 and became the primary investigator in the case?
So a couple of the things we wanted to establish that the burner phone that Detective Roberts had discovered was purchased in Alaska, several miles from Austin's known residence. We wanted to try to show that that likely belonged to Austin. So we asked for an analysis to be done to show that calls that were made from his known number were the corresponding data from the burner number, that two of them seemed to appear to use the same cell tower, which to us suggested that the burner phone was being used by Austin.
And you included that later in October of 2024. I'm sorry, in October of 2024 in your probable cause statement that you and your partner wrote?
Yes.
Okay. And what else did you find after you became involved in the case that you believed was an element of the probable cause to arrest Mr. Austin?
When we received the airline records, the changing of the ticket, the documentation which showed the adjusting of the ticket from the scheduled return on the 24th of January to the 23rd of January, where he paid a fee to return early. We found that to be significant, that it was 6 hours after the murder that he seemed to abruptly leave the Los Angeles area after having only been in Los Angeles for a short period of time.
But you already had those documents when you came into the case, and it was after that you identified that you believed they were significant?
Yes,
Like that is since that's not evidence.
So,
yes, that information was significant to us, but it was reiterated through the warrant that we did to ensure that that information was correct.
What from the return on the warrant that you did after you came into the case was different in your analysis from the information you had from before you came into the case that showed he changed his ticket?
Well, we wanted to ensure that there wasn't additional flight information that would suggest that he left on, or that he left on a different airline, or that there was additional travel. I also have a recollection of a reserve police officer doing a follow-up to the airline to determine this change, because it's very hard to read those records if you look at them. They're not very clear, but that the change information was done at the LAX counter, so we wanted to ensure that that was correct.
But you already had that information when you came into the case?
I believe so.
Okay. And anything else that you obtained or secured as a result of your investigation that you identified as a new element of probable cause in order to affect the arrest of Mr. Austin?
Not that I remember.
You've told us quite a bit about the significant operation by robbery homicide to affect the arrest for Mr. Austin for first-degree murder, correct?
For the probable cause arrest warrant for murder, yes.
Okay. And that was for first-degree murder, correct?
We don't assign the degrees of murder. It's murder is the penal code section that we ask for the probable cause arrest warrant for.
Okay. So you were not asking for a probable cause warrant for first-degree 187 murder?
I asked for one
Hello,
probable
Music Man.
cause arrest warrant for 187 PC murder.
Okay. You didn't ask for a probable cause warrant for second-degree murder?
No.
And I think you testified that you had 8 other robbery homicide detectives, or 6 others, and you and Detective Byers and a robbery homicide lieutenant, plus the Perkins detectives when you flew up to Vancouver, Washington at the beginning of October. Is that right?
Correct.
And
Thank you,
prior
June.
to flying up to Washington, you had applied for this Ramey warrant, correct?
Yes.
And as part of the application for the Ramey warrant, you and your partner submitted an affidavit, a sworn affidavit about the probable cause and your work on the case to support a judge hopefully issuing an arrest warrant for Mr. Austin for homicide, correct?
Yes.
And as part of that affidavit in support of the arrest warrant for homicide,
Hey, June, I don't know where you put the documents. All I see is your message. I don't see the actual documents. Did not download.
Am I correct that you indicated in the affidavit that the detectives, and I assume that's you and your partner, believe evidence recovered from Austin and I assume his residence may establish a nexus between Christopher Austin and Monica Sementilli?
Yes.
Would it be accurate to say that in that affidavit in support and in your work in the case prior to flying up to Vancouver, Washington to arrest Mr. Austin, you were looking to determine a nexus, if one existed, between Mr. Austin and Monica Sementilli?
Well, I mean, that would be part of the
Thank
investigation.
you for your help, June.
The investigation thus far has suggested strongly her involvement in this murder. So wanted to know, as we believe it to be a conspiracy to commit a murder, what her role was in relation to Mr. Austin.
So the answer would be yes. That was one of the reasons you were going to Vancouver, was to see if there was a nexus between Christopher Austin and Monica Sementilli.
The answer is yes, that was evidence that we hope to obtain in the arrest and or search of the locations associated with Christopher Austin.
Detective, prior to going to Washington, what evidence specifically did you have that there was any nexus or relationship between Christopher Austin and Monica Sementilli?
Indirectly, we knew about the relationship between Mr. Baker and Monica Sementilli,
Okay.
and then we established the relationship between Mr. Austin and Mr. Baker. So that's why we were seeking that information between any nexus or connection between Ms. or the defendant and Mr. Austin.
So is the truthful answer no, you didn't have any direct evidence of any relationship between Monica Sementilli and Christopher Austin at the time you went up to arrest Mr. Austin?
Objection argument.
That's form sustained.
Detective Farrell, let me ask you again, what specific direct evidence did you have at the time you flew up to arrest Mr. Austin for murder of any relationship or contact between Ms. Sementilli and Mr. Austin?
The evidence that we had suggested much contact between a person we knew to be involved in the murder of Fabio Sementilli, Mr. Baker, and a connection between the defendant, Monica Sementilli, and Mr. Baker. We established or believed that Mr. Austin was the second suspect who's seen in the jogger video. So we knew it to be a conspiracy to commit murder against Mr. Fabio Sementilli. So we were seeking that evidence.
So is the truthful answer no, you didn't have any direct evidence of any relationship or contact between Ms. Sementilli and Mr. Austin at the time you flew up to Vancouver?
Objection argument.
Sustained.
Mr. Detective Farrell, when you flew up to Washington to effect Mr. Austin's arrest for murder, you also executed or asked that a number of search warrants be executed for the seizure of evidence from Mr. Austin and his residence?
Yes.
And a good deal of evidence was seized?
Some electronic evidence, yes.
Okay. And that electronic evidence included computer devices, cellular devices, correct?
Yes,
Telephones?
yes.
Was other evidence seized?
I'd have to look at the property report, but I think that the bulk of it was electronic evidence.
And for each of the pieces of evidence you seized, including the digital devices, those were analyzed?
Yes,
Okay. And they were identified as being Mr. Austin's?
some of them, and some of them were shared devices.
Okay.
Some of them were identified as not belonging to Mr. Austin at all.
Okay. And of all the devices that were seized, both those belonging to Mr. Austin, those, I assume you're talking about devices were seized from family members as well?
Yes,
And then what devices were seized from people that were unrelated to Austin?
his wife's cell phone was seized.
Okay, that was a family member. Were there any non-family members whose computers or devices were seized?
Not to my knowledge.
Okay. And there was an analysis performed of communications, messages, texts, phone calls?
Yes,
And am I correct? Nowhere in any of the evidence that was seized and reviewed by you all and analyzed and obtained, did you find any evidence on the property seized that had anything to do with Monica Sementilli?
correct.
You testified about a very extensive Perkins operation that you supervised to have conducted as part of your operation going to Washington, yes?
Yes,
Jackie states the evidence regarding supervised.
It's overruled.
I participated as an investigating officer in it, yes. The Perkins unit works independently of the investigators.
So they were already on the case at the time you came into the case?
They're a resource, much like a surveillance unit, that you ask for their assistance in the case.
Okay. And did you ask for their assistance?
Yes,
Okay. Did you make arrangements for them to accompany you up to Washington?
yes,
Did you, I think in your testimony, you were asked about a briefing of the Perkins team?
yes,
Did you participate in that briefing?
yes.
And when was that briefing?
It was the day of the operation, October 2nd.
Okay.
Recess for 15 minutes. The admission applies. See you back here in 15.
He's going to go get himself a donut. Who's trying to bribe the judge? That's what I want to know. Who's bribing the judge with the donuts? Yep, somebody gave Judge donuts. Y'all, that is not healthy. We shouldn't be eating donuts. Oh, how are y'all doing? Ugh. All of that dancing and partying I did last night, my gosh, my body is now saying, honey boo, just because Cece's 60 years old and been dancing like that for years doesn't mean you can. I don't dance. I don't exercise. I have rheumatoid arthritis real bad and I have joint problems. So there's a lot I don't do. But it was so awesome. So awesome. Awesome sauce. Okay, I'm looking in my Discord, trying to catch up with everybody. Okay, if anybody can get their hands, I wish Toxic was here. Trying to get my hands on that federal transcript, although it's going to be a thick book, I'm sure. Court donuts are they declared legally healthy? Is that what you're saying to me? That they have declared donuts legally healthy? Y'all, then I'm gonna go get me 24 donuts. I'm losing weight very slowly, but I'm losing weight. That's a good thing. It's not easy. Oh, I'm trying to find something for us to watch for the 15 minutes. This particular, we're going to watch this. Is all over the place. He's been seen a lot, but I like listening to what he said.
Joining us live tonight from Massachusetts, Ronnie Stanislaw. Ronnie, I know we've got about a 1.5 second delay here, so thank you so much for joining us tonight. We really appreciate it.
Thank you for having me.
Let me start right with the headline. I'm going to get right into it, Ronnie. Did all 12 of you inside that jury room agree that Karen Reed was not guilty of murder? Count 1 in that indictment.
Oh, by the way, Sarah Boone's motion.
Correct.
Okay, now let's roll up our sleeves a little bit. How did
I don't know if y'all knew that or not. You probably did. The appellate court denied for the extension of time to serve the initial brief was denied without prejudice as moot, and the clerk of the lower tribunal has not transmitted the record to the court seat of Florida. Denied.
Did you vote? Was there a raising of the hands? Was there someone writing down what your vote was? Was it a secret ballot? How do you know, and how was the process that all 12 agreed that she was not guilty of murder? Count 1.
So we all raised our hands in terms of a vote, and we voted on that first count that we all agreed not guilty. Unfortunately, at that time, we did not fill out any of the paperwork there, nor sign it. So we were under the understanding that each charge could not be treated separately. And so we continued to deliberate, despite the fact that we had agreed on 2 of the counts as not guilty.
And the second count was count 3, and the same process where I guess the foreperson is asking for a vote and everyone raised their hands?
And everybody agreed not guilty for those 2 charges. That's correct.
Was there, now you mentioned that you didn't fill out paperwork. Was there any discussion about should we check the box on the verdict slip?
So we didn't check the box on the verdict slip because we were still deliberating on the second charge of involuntary manslaughter, and that continued with deliberation. We did send out notes asking for clarification, but unfortunately we did not ask the question at the time, should we treat each charge individually and separately?
So explain to us why the presumption was that you had to come to a conclusion on all 3. Was there any debate among the jurors about whether or not we have to agree on all 3 counts, or it can be just 1 count, or it can be 2 counts? Was there any discussion or debate amongst the 12 of you about what the rules were when it was time to fill out the verdict slip and determine and let everyone know where you were in these deliberations?
So one of the big things that happened was we all agreed and voted, and we kind of not came back to any of those charges. We never revisited them because we had already voted on them. And then we kept on debating on that second charge. And because we kept on debating on that second charge and deliberating, that kind of got us caught off guard at the end in terms of how to respond to that and whether to ask. There was a couple of us who did clearly indicate that maybe we should ask about treating each charge independently, but the majority overruled, and essentially we were left to believe that it needed to be all or nothing.
See, that's interesting. See, that's fascinating. That's something I would think the folks in Massachusetts would be interested in, is that now you're talking about there's debate about the rules within the jury. See, I look at that's the fault of the system, not in informing you ahead of time about these things. So let's go through, because you all sent out notes. I want to put up the first one that was sent out. I believe this was the one on Friday. Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all of the evidence, we have been unable to reach a unanimous verdict. So that first note from Friday, which I believe was actually the second note that you had sent out, what was the status? At that point, had you already finished on 1 and 3?
To my understanding, on Friday, we had already finished on 1 and 3, and we were stuck on that second charge.
So when you all sent that note to the judge, what type of response were you expecting? Did you have any expectations about what would happen after you sent this note to the judge?
The expectation was she probably is going to send us back to continue to deliberate given the circumstances. So that's where it stood.
Okay, and I always wonder about that, right? Because I cover trials for a living. I know the judge is going to send you back, but I never know what, folks who don't watch trials all the time like I do, or have practiced law, if they expected that. But those were your expectations that, listen, we're stuck, but we know we're not done here, so we're going to have some more work to do. Let's get to the second note. So this is now, that was Friday, come back on Monday. I think this is Monday around 11 in the morning or so. The second note, it's actually the third jury note, but the second deadlock note. Judge Cannoni, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. At that point, sending that note, what were your expectations and the expectations of your fellow jurors about what's going to happen after you send this note out?
I think at that point we knew it was an impasse because we were stuck. We were continued to deliberate, but despite continuous deliberation, as clearly indicated in that note, there were beliefs that were not going to be changed. And as a direct result, we could not find essentially a decision that would be unanimous. And therefore, it would be a futile exercise in terms of, and that's the unfortunate thing, is it wasn't clear that that was only on one charge. It clearly is indicated by all those notes. It seems like we were in deliberation and we were in an impasse on all 3 charges, but that was not the case. And unfortunately, we never asked that question to treat it as 3 separate charges independently of each other.
So when you send this note, were you expecting that this was going to be the end of the case, that everyone would be going home after this? Were you expecting anything else to happen, any other sort of response from the lawyers, from the judge, from anyone after sending this note out?
In my mind, no. I believe that that was it. We were going to be done, and it would be a decision from there that it would be a mistrial. But that was in my mind. I don't know, and I cannot speak for the other jurors.
Absolutely. And again, thank you so much for joining us. The folks who watched the trial, invested in it, and are very confused by all of this. This is really opening up a lot of eyes. Let's take a look at the final note. So this is the one later on that same day, on Monday. The final note: we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. Now, a lot of people have focused in on two words that were written twice in that note: the charges, the charges. Everyone who's looking at that is saying, well, they were talking about the charges, and there's 3 charges in this case: count 1, count 2, count 3. So why was it written the elements of the charges? What was that supposed to represent and mean in that note?
I think during the time frame, it was still very clear to us, or at least the majority, that it had to be all or nothing. Again, not treated independently of each other, and hence the verbiage that was utilized in those notes indicating that it should be charges, because again, we as a jury were treating it as such, that it had to be all or nothing for all 3 charges, not to be treated independently of each other.
I get it. I get the mindset. All or nothing. The charges are the charges. If we don't come to a conclusion on all 3, then we're having trouble dealing with the charges, as opposed to saying the charge or count 2. Let me ask you this. As you all were focusing in on that second count, what was the debate there? What were you looking at, and how close were you? What charge were you considering in that second count?
I believe that most of us felt that she was operating a vehicle under the influence of alcohol, and that played into it. However, to some individuals, there was reasonable doubt on the mechanism to which Mr. O'Keefe actually succumbed and died. So I think that had a play as well. So those were some of the factors that were being discussed in that jury room.
So it's 12-0, 12-0, not guilty on 1 and 3. Let's go to count 2. What was, by the time you finished, after all these notes and the deliberations, what was the split, and how many, and what exactly was each faction voting for?
It kept changing. At one point in time, it was split 50-50. And so 50-50 initially, 6-6, then started to, based on debate and deliberation, it became clear, and we all kind of agreed that she was operating, or anybody for that matter, if they were operating a vehicle during that time frame and with all that alcohol, was probably under the influence of alcohol and should not be operating a vehicle. Then it changed.
But then again, what's happening is that is reasonable doubt. I feel the jury did not fully understand what reasonable doubt was, in my humblest of opinions.
To between 8-4 versus 9-3. And ultimately, I don't think we came up to a final conclusion on a final tally as a direct result of it continued to be stuck And it was very clear that some people were under the mindset and the belief that she was not guilty. And so at that point, those notes were continuously passed, ultimately with the final note.
And I've heard different things at different points about what the guilty votes were for. Was it for the top count of was it for the top charge in count 2 or any lesser included charge within that second count?
Thank you, June.
So it was, I'm sorry, can you clarify the question? I just want to make sure I'm answering it.
Absolutely.
based
So
on your
within
question.
count
Yeah, no
2,
worries.
where you have 6,
Yes.
then 8, then 9 people believing she's guilty, was it guilty of the charge in count 2 or a lesser included charge within count 2?
It was a lesser included charge within count 2 at one point.
Okay, we've gone through the deliberations. When we come back, Ronnie, what I want to do is go through some of the moments and some of the evidence in the case and get your perspective on all of it. This is really eye-opening. Ronnie Stanislaw is going to stay with us the whole hour as we continue taking you inside the jury room in the Karen Reed trial. We'll do that, plus coming up next hour.
Tonight on Vinnie Politan Investigates, the murder of 13-year-old Madeline Soto. Newly released images from the home, from the car, and of Stephen Stearns are giving us new insight into the case. Tonight, we investigate.
Did love. I got
Join Court TV's Vinnie Politan with the latest and breaking.
Okay, we're going to put that on hold. Do you know why? We got Karen Reed documents, and we got them because of only one person. Yep, we do. Thank you so much, As the Gavel Drops, for your continued support of our channel and your documents. Go to Gavel Drops in Discord, register, validate your account, and you too can have access to all these documents to read at your leisure. Remember, if you share them publicly, please give credit where credit is due. Once again, we love you and we thank you as the gavel drops. Oh my gosh. We got document, y'all. First document. Kohlberger. There's a lot of lawyers in the District Court of the 4th Judicial District of the state of Ohio and in the county of Ada. Whoop! My county. State of Ohio versus Kohlberger. Comes now Brian Kohlberger by through in the attorney of record in which no objection from Lath County Prosecutor's Office and hereby moves the court for an order to seal the defendant's exhibits in support of the motion to strike penalty RE autism spectrum disorder. So they want to seal that information, and my ears are echoing real bad. They want to seal the information, and the defense seems to be okay with it. This is made in pursuant of I period C period A period R period 32 parentheses I and I period C period 74-124 parenthesis 1B parenthesis and C parenthesis. Why? Because they are either previously already sealed or redacted. For the purpose of this motion, the court will need to see a full document, and therefore non-redacted copies are being filed under seal. There you go. Okay, here we go. Karen Reed. No, that is not what I want. That is not what I clicked. Okay, in the Karen Reed document, the supplemental exhibits in the support of the defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. Now comes Karen Reed, Miss Reed, and filing the following supplemental exhibits in support of the defendant Karen Reed motion for dismiss extraordinary governmental misconduct. This is all the stuff that Auntie Bev wanted. the correct version of the inverted Sallyport garage video, actually accurate reflecting the right rear tail light and being the right rear tail light. Counsel specifically directs the court's attention to 1.15 to 1.49, during which time Trooper Proctor approaches the unvetted access to the right rear tail light. By the way, I find it interesting that they're not talking about the two other unidentified officers who were seen bending over, squatting down. You could see their heads popping up and down right next to him. He was talking to them. All right. Mrs. Reed says she be submitted. Footage also shows unidentified individual apparent and then disappear. Says apparent and then disappear from frame near. Okay, there they go. There it is. That's where it is. Photograph of the condition of the right rear taillight of Miss Reed's SUV in the Canton Sally garage on February 1st, after Proctor and other Canton PD department had access to the vehicle. Taillight appears fully damaged, not cracked. Photograph of the reconstruction of the taillight with pieces of plastic recovered from 34 Fairview. Even after full reconstruction of taillight, it appears cracked and missing a piece consistent with Sergeant Burroughs' testimony regarding his observation of the right rear taillight in the Lexus SUV at Mrs. Reed's parents' house in Denton on January 29, 22, before it was seized by law enforcement. Sorry. Certain pieces of plastic missing from the taillight were never located or recovered from 34 Fairview. Photograph of the 47 pieces of plastic taillight lens material recovered from 34 Fairview. Fairview items. Screenshot established the Commonwealth Exhibit 2, which purports to show the interior Sallyport back wall. Camera was also inverted on 122. We saw that yesterday. Has different colored irons, and the 1.21, 1.2922 inverted video produced to the defense on April 4th from the same camera. There were differences. Timestamp on the top versus the bottom. There were differences. That camera had to have been tampered with at some point. The disciplinary suggest manipulation further underscores the prejudice to misread by the Commonwealth, destruction of the original file and metadata associated with the download of the surveillance footage from Canton PD. Respectfully submitted. So they're just cleaning up their mess is what they're doing. Okay. And here's the supplemental motion for admission to pro hackvis of Mark Bedrow. Dr. Urinetti and Mr. David Urinetti of the Urinary Criminal Defense Firm, member in good standing Massachusetts Bar, hereby moves to admit pro hackvis Mark Bedrow so he may associate in the counsel of record for the defendant in the above captioned matter on the following grounds. At the court's directive, affirmation is intended to supplement in my pleading motions for Ms. Pro hackvis of Mark Bedrow so that Mr. Bedrow may represent Karen Reed at her upcoming trial before this court. I incorporate by reference all contents of my previous information in support. So basically, this is just saying who he is and what he's done. He's in good standing. The court is aware he presently resides in Aden Kearney, represents Aden Kearney on 3 criminal cases in Massachusetts. One case involves several witnesses who are scheduled to testify in Ms. Reed. Prior to the filing of the incident motion, Mr. Bedrow conducted separate and extensive discussions with Reed and Kearney. He defined and explained actual and possible conflicts of interest and the concepts of waivable conflicts. He explained to Ms. Reed and Mr. Kearney the possible conflicts that could arise in his representation of both separate matters that involved one of the same witness. He answered any questions either client had after both clients expressed their interest In his reputation, they consulted with their own counsel. Both Bedrow and I are unequivocally confirmed that there is and nevertheless has a joint defense privilege between Reed and Kearney. So basically, Mr. Bedrose had no role in preparation of the recent motion filings with the court, which led to the Commonwealth to seek sanctions over the alleged violation of the protective order due to the inclusion of the text messages of Michael Proctor. Mr. Bedrow was not provided any protected material by Ms. Reed, her counsel, or anyone else in conjunction with the motion. Shortly after the motion was filed, Mr. Kearney's attorney filed a motion to dismiss the indictments against him. The motion included references to some of the texts and electronic communications that were subject to protective order in the case. Publicly filed version of the motion. I'm just kind of going, so this filed on February 18, on February 18, 25, the Commonwealth stated it did not object to Bedrow's admission to pro hac or defense providing additional information to the court ex parte before the court decides on the motion. Open a browser. Show this tab. Expand. Ooh, here we go. Admission. Oh, Mark Bedrow is denied. Oh, the affirmation of the support of the conflict of interest that is not waivable under Massachusetts rule professional responsibility. I knew she was going to do this. One such conflict, especially outlined in the motion paragraph 8, where Mr. Bedrow apparently speaking through Mr. Urinetti promises to restrict his use of certain information. The clear influence of the promise is that Mr. Bedrow would not use protected information gained in the representation of one client for the purpose of representation of the other. He thus proposed to ignore information to him through his representation of one client, even though where the information may benefit his second client. The court cannot permit much such conflict representation and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by admission of pro hac. Order supplemental motion denied. Freaking Beverly, I want to say the F word so bad. I want to say the F word so bad. I do. Thank you so much, Toxic, for that. So he's denied. They don't get the attorney they want. He's denied. Denied. This is pissing me off. See, the defense doesn't get anything. The defense is winning absolutely nothing in this case. And do you know what? I get to a point that some people feel that this is unfair advantage, but I don't think so. I've got to find a sound that represents Beverly Cannoni. Y'all help me out. Describe. If you were to get a sound effect that represents your disdain for this judge. I never thought I would be this disdaining of a judge. I never thought I could find myself so wrapped up in disliking a judge as much as I do. I am absolutely floored. Toxic, I love you. I want to do a movie night tomorrow night. I'm looking at several movies. Don't know what to play. Y'all let me know what you want. Oh, thank you, Angela. Just got it. Thank you, dear. Thank you, dear. So thank you, Barbara, for liking. Thank you guys for joining. Everybody, please comment. Of course, we love your comments. Like, subscribe, click the bell so you know when I go live again. Use ducking Bev. What does that mean? Get a little more descriptive. Ducking Bev. I have a ducking, but I don't. What does the ducking do? I'll have to Google. We need to find something for Auntie Bev. Nasal. And so therefore I deny just because I don't like you. I mean, yeah, that breathing is just too much. Absolutely too much. By the way, this is disheartening news. Los Angeles, there's a $10 million reward for the $10 million reward for the information leading to the arrest of a former Olympic snowboarder for Canada who is wanted for allegedly running a multinational drug trafficking network and orchestrating the multiple red rooms related to the drug ring. The FBI added the 43-year-old Ryan Wedding is added to the top 10 most wanted list on Thursday while announcing the U.S. Department's $10 million offer. Wedding went from the dreaded powder on the slopes of the Olympics to the disturbing powder cocaine in the streets of the United States, and it is native Canadian. The alleged red rooms of his competitors make Wedding a very dangerous man. Y'all. That's so horrible. Oh, I got you. Ducking, Deb. Duck it. Duck you. Got it. My brain is still asleep. I didn't get to sleep until after 2 a.m. I'm tired. That concert was awesome. But I'm tired. I'm very tired. So, yeah. What was I playing before? Oh, this.
Now, let's look at the other side of all of that.
Did anybody see anything? What happened? And there was one individual that replied several times, I hit him.
You indicated that the defendant said, I hit him. Is that correct?
Yes.
Is that something that she said once or more than once?
3 times. I hit him. Earlier, it was could I, did I? When she spoke to the paramedic, it was crystal clear. I hit him.
And there were more witnesses that said the same thing, and prosecutors argued it was a confession by Karen Reed that she struck John O'Keefe with her car. What did the jury think of that? Still with me, a juror from the first Karen Reed trial, Ronnie Stanislaw. So, Ronnie, did you listen to those witnesses, and did you hear a confession from Karen Reed, and do you believe that she confessed to striking John O'Keefe with her SUV?
I did not hear that. To me, it was not a confession. I believe in a moment when somebody's stressed, they may be saying things. The group found it interesting, and I found it interesting that that was what everybody kind of remembered, when usually in the heat of the moment and the stress of the moment, when taking care of a patient, you focus on taking care of the patient and not necessarily what others are saying in the background. So we looked at it, but we moved on from it.
Interesting. Let me just follow up on that for a second. Do you believe that they were coached into saying that or misremembered? What do you think?
I believe that at the time, certain people may say things. I don't know, honestly. And speaking for myself, I could say that I did not put any merit in it. And there may be some sort of coaching or kind of rehearsal, knowing full well that you're going to be testifying. But again, in the legal system, I don't know how that actually works out in the end to the jury, but the jury obviously some individuals can take it as such, and some people can actually look at it as something differently or dismiss it.
Interesting. I mean, are you a paramedic, so you would have some experience in dealing with folks?
Yes.
Oh, so that's what I love, when jurors bring their own life experience in and can mix through and parse through some of the things and apply a little common sense to all of it. That's awesome. I want you to take a listen to the two medical examiners now, because that testified in this case about the injuries and what they signified. Let's take a listen.
The cause of death was due to blunt impact injuries of the head and hypothermia. When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs.
Would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
Are every injuries from a pedestrian collision the same?
No.
Are those injuries consistent with an animal attack?
Are they consistent with what?
An animal attack.
I would say they are, yes. I'm not 100% sure about this, but my initial reaction when I saw this photograph was that it was probably an animal.
Based on your extensive training and experience, what is your opinion regarding whether those injuries are consistent with being struck, with an individual being struck by a vehicle?
If you mean struck in that part of the body, on the arm, like directly, I would say no, it doesn't look like that at all.
He has a cleft.
Okay, Ronnie, let me ask you. You had those medical experts. You had the trooper who testified about the pirouette, as described by Alan Jackson. You had the experts that were brought in by the defense as well, called by the defense. Did any of this evidence convince?
I dislike the judge because, first of all, I'm not listening to anybody else's opinion. This is my own humble opinion. That's why I say a lot of IMHO in my own humble opinion. I don't feel that this judge is handling this case appropriately. I feel she's got biases. I don't know anything about her history with the family. Everybody else can go into that, how she supposedly somehow somebody that's connected to somebody, in this case, Vendo money, all that kind of stuff. I'm not looking at that. I'm looking at the way she talks to the defense, the way she talks to the prosecution, the way she's running her courtroom. And I am flabbergasted at the way that, you never win every one of your motions. We know that. We get that. Okay. But it is a clear bias after the way she treats the defense compared to the prosecution. I believe she's biased. And honestly, I don't think she should even be on this case to begin with, because she's been moved from criminal court to family court. And I also don't believe that a judge who has heard a case that has gone to a mistrial should be hearing the case again. That's my own humble opinion. It's not law. The more I've gotten into the criminal justice system, I am going to college right now. I am graduating in December with a degree in criminal justice. I have to tell you, I'm not liking how she runs her courtroom in this particular case. The other issue I have with Auntie Bev, and I don't even like to call her a judge, is I've watched her in a different trial, and she behaved totally different. Very equal to both sides. Her tone, the way she talked to them, the way she handled their objections, the way her court was run was a fair and a more balanced court operation than what's being done here. So I came into this case knowing nothing about anybody. It was at the very beginning of my start to doing this. It was my first big case. I came in it like a juror. I was looking at everything like an alternate juror. And by the end of that case, I wanted to slap her. I did. Because I don't think she is interested in doing anything in a fair and equal way. I think once she gets upset or does not like something that a defense or prosecutor, if she doesn't like what you've done or said, that's it. She's done with you. And that's how I feel. However, I'm the type of person when we go back into trial, this next time, I'm going to put all that aside, put my blinders on, engage everything based on what is testified to and how things are run in the court this time. But it's going to be hard. I think Auntie Bev should have recused herself. Even if she didn't do anything wrong, I think it's important to recuse herself to maintain a sense of impropriety in the system. And I think that she is like a rabid pit bull on raw meat, and she's going to hold on to this case until it's done. And I think that that's a bad decision. And I think she needs to remove herself. And I think they need to find a impartial judge. That's why I say all the time, if a trial has ended up in a mistrial, they should have a second judge come in, because it's just too easy to take sides, especially in her case.
Convince you one way or the other about whether or not John O'Keefe was struck by a car, that the injuries were consistent with being struck by a car.
This is where we debated for hours. And so some of us believe that there was injuries there, and the injuries were after Karen had dropped him off. And therefore, those two individuals were there at that location. And ultimately, John O'Keefe was dead in the front lawn. And so for some of us, it was conclusive evidence that she was guilty. For some of us, though, the injuries were not consistent with a pedestrian struck per se. It wasn't the standard. I understand that there may be different mechanisms, but there was not enough evidence or testimony given on how it could be not the standard pedestrian struck with extremity injuries. And so it seemed inconsistent. So for some of us, it solidified that essentially it was not a collision with the motor vehicle that ultimately caused the blunt force trauma to his head.
And which camp were you in? Did you believe it was the car, or did you believe it was something else?
I believe that it may be something else. So it was not, it created reasonable doubt as to what they were presenting as the evidence in the testimony.
What did you think of the cuts on the arm of John O'Keefe? Did you believe it could have come from a dog?
Paramedic.
Again, it wasn't conclusive. To me, it wasn't conclusive whether it was an animal or just abrasions due to glass or scraping against metal. But there was no conclusive evidence on where it actually originated from and where those scrapes or abrasions, how did they get there per se.
Okay, let's talk about the tail light of the SUV. It was broken. It's clear it was broken. I'll start with your perspective. How do you believe the tail light was broken? What caused that?
some sort of impact, clearly, that caused the breakage of the taillight. I think in terms of testimony, we would have preferred that the Dighton police officer who testified clearly indicated a little bit more information on whether the broken taillight was consistent to when he first saw it at the location at the Reed's residence versus, and then it was towed. And then also it would have been nice to have some sort of testimony from the tow truck driver who transported it to the Canton Police Department, because in that sense, we would be able, whenever you...
I asked the same question, first of all. Second of all, look at this taillight, you guys. Okay, I want you to look at this picture. When she's pulling away from the house, see all this from my arrow all over here, all of that white area? That would have been like having a high beam flashlight. It would have been solid white. It wouldn't have been yellow red. This area that my inside that I'm drawing here is white. It looks like a little kind of like a very slanted eye. That's supposed to be white. Everything below that line is supposed to be red. When you look at her pulling out of the house, when you look at that video and we get a clear shot, all of this is red. There's a little beam of white over here. So that is vastly different from what you see on the video when she leaves the house. Vastly different.
You move a vehicle, usually you take pictures or note any damage. So I would imagine that that tow truck driver probably would have had some sort of information, unless he did not do due diligence and actually write down any kind of damage on the car prior to moving it to the Canton Police Department.
So I want to show you what we call the Sally Port video, which is when the SUV is brought into the Sally Port. It was presented in two different ways, right? On the left, the prosecutors brought it in that way, and it was inverted, and it was backwards. So left is right, right is left. So when you're looking at the right taillight in the exhibit presented to the jury by prosecutors, it's actually the left taillight. Did that bother you? Were you offended by the fact that the video presented by prosecutors actually inverted the video and made left right and right left, and they didn't tell you about it?
It was quite confusing because when we actually looked at it, we said, oh, the taillight is intact. Versus when you look on the other side, there seems to be some sort of damage potentially. So it did kind of affect our thoughts, but ultimately we tried to look at the timeline, and if it was possible that there could have been some tampering with the vehicle prior to its arrival to the Sally Port, but we kind of dismissed that and moved on. Kind of looking at the overarching information that there was an injured individual who ultimately died on the front lawn. There was a motor vehicle with some sort of damage to it, and somebody who was operating the vehicle who was clearly indicated to be under the influence of alcohol.
So from your perspective, you moved on and didn't really determine one way or another if Trooper Proctor or anyone else tampered with that taillight?
We didn't feel like there was any tampering per se because of the fact that it didn't seem like there was the appropriate timeline to actually do some tampering and then get it to the lawn or the crime scene within the correct time frame.
Gotcha. Wow. What a great jury. Thoughtful, smart. Ronnie Stanislaw is going to stay with us. We got you in lockdown for the hour, Ronnie. You can't go anywhere. Thanks so much. We're going to continue this conversation because there's more evidence and some more questions like, does Ronnie believe justice was served? That's a big part of the story in the Karen Reed trial, which was everything that has happened on social media, in the local community, and obviously at the courthouse. Let's bring back in our special guest tonight, a juror from the first Karen Reed trial, Ronnie Stanislaw. Ronnie, did you guys have any idea, did you personally or other jurors have any idea about what was happening outside the courthouse? I mean, the dozens and dozens of people, many of them wearing pink, that were there day in and day out.
We did not allow them to distract us in any way, shape, or form from our charge and what we were responsible for doing, which was to listen to the witnesses, the testimony, and the evidence, and deliberate and ultimately try to come to a conclusion. So we did not allow that to distract us in any way, shape, or form.
But you guys had an idea that there were a bunch of folks there and they're very passionate.
We could hear them at times, obviously, but again, we didn't allow it to distract us from our job at hand.
Fantastic. Let me ask you a couple of big questions here. And we discussed that you all came to a 12-0 not guilty on counts 1 and 3.
I want to share this with you so you see what I'm talking about. Look at the red glow all down in here. All of that would be white as a piece of paper if it was missing, in my humble opinion. See how orange red it matches over here? It matches. You have a little missing up here, but that's what's confusing me. Look, the day video camera from the street, 11:28. Look at it. Down here, look at it. 11:29. Yep. Yep. Just humbly saying. We are still waiting for the other trial to begin. Go back.
Which is enormous. You invested a lot of time in all of this. Who is at fault for this confusion from your perspective? And this confusion that you guys did your job, you came to a verdict on 2 of the 3 counts, yet somehow, some way, it all slips through the cracks. Like, who's at fault, do you believe?
I think we were responsible as the jury because we did not ask the right questions. I think there's always the justice system. We're not professional jurors, and we don't know the justice system like lawyers would know and those who are in the system. So some instruction would have been great, but I think moving forward and knowing this, I think people need to know that it's okay to ask questions. There's nothing wrong with asking a question. And I don't know if we were just intimidated as a jury to be asking and not feel stupid, for lack of a better term, to ask the question that could we have looked at the charges independently of each other. So I think we unfortunately failed the system to ask that, but it could also be a combination of the system not giving enough instructions.
Yes.
Again, like, we are not professional jurors. This is something that people don't usually do and don't know exactly the rules. So shame on us for not asking the question, and shame on the system for not could be clearly indicating what can be done and can't be done.
Let me just say, Ronnie, no shame on any of you. No shame on any of you. You get called down there, and you are 12 who invested all that time. You are the 12 who didn't come up with some excuse why you couldn't do it. It's your civic duty. It's shame on the system, 1,000%. I'll answer that one for you. And I think you're just being nice. And let me ask you this, though. What is the takeaway from you, having gone through all of this? Do you feel that there's an injustice now going forward in this case? Do you feel disappointed? Do you feel angry? Do you feel confused? What is it that you're taking away, having gone through all this and seeing the way that it sort of ended up?
I think disappointment in terms of not having to provide closure to the families and to everyone. I think we were tasked with a duty, and we didn't provide any closure at the end. I feel like it is going to be another extra resource when, if we had just clear direction at that time, we would be able to make a decision on 2 of those counts, and therefore this might not be a conversation that we may be having. So unfortunately, it is what it is, and I understand also why they do not or have not approached us to look at what went wrong, because in terms of now looking back at it, we've been out too long to know or investigate further on our own, and that would have tainted the evidence and ultimately the deliberation process of the vote. That's why deliberation is very specific, and that's when the first time we're supposed to look at the notes and the evidence and debate amongst ourselves and not with others. So I can see how that's ultimately where we are. I just hope that in the future, there is now hopefully direction, a little bit more direction and clear directions so that it can be looked at as individual charges. And I'll be interested to see what the results are, but it may actually remain the same in terms of the 3 charges, right? I think
it looks that way. They've gone to federal court, so it could change. A federal judge could step in and have some curiosity. Let me play something for you, because all those folks in pink, this was one of the big issues for them initially when this case was being investigated and Karen Reed was being charged. It was about a Google search that was done by a witness named Jennifer McCabe. Let's take a listen.
You see this first search that says hospital to dying cold?
I do.
What's that time?
You've got the, it's right over at 2:27
AM or PM?
a.m.
Ms. McCabe, you made that search at 2:27 a.m. because you knew that John O'Keefe was outside in your sister's lawn dying in the cold, didn't you?
Absolutely not. I did not make that search at that time. No.
Realized the next morning, after John was discovered, after 6 a.m., that you had an incriminating search on your phone, didn't you?
Absolutely not.
To cover your tracks, you searched it again in order to overwrite the original search at 2:27, correct?
Again, absolutely not.
Okay, Ronnie, your thoughts about the Google search?
I wish we had more testimony in terms of how it actually acts. So an expert to say, when you do a Google search at 2:00 in the morning, it's there. And even if you search it again at another time, it's supposed to always be there, and it's part of the history. If there was some sort of other expert who kind of would talk about that, it would have been great for clarification.
No, this is actually one of the jurors.
Purposes. But again, not enough conclusive evidence for some of the jury to convict or not convict.
Let me play something else for you. Here's Alan Jackson cross-examining the lead investigator from the state police. I know you know who I'm talking about, Trooper Proctor.
Your assessment, personal assessment, that Karen Reed had struck this officer with a car, gave you license to call her a
It was my emotions that gotten the best of me.
and you called her a whack job. Gave you license to call her that too.
Yes.
Gave you license to say to your friends, oh, no. She's right?
That's what I wrote.
Gave you license to say that she's a
Again, another disgusting comment.
You get to talk about her leaky balloon knot, right?
Objection.
Okay, Ronnie, do you think Karen Reed was treated fairly by Trooper Proctor in leading this investigation?
His behavior was not very professional. And so his testimony was treated as such by some of us because of that damaging information. That being said, he was not we looked at the evidence as a whole, not necessarily just that one piece, but definitely unprofessional and unbecoming for somebody who is in law enforcement and in a position of power.
Okay, we only have a little bit of time here. What do you think happened?
I honestly do not know. I know that ultimately there was some sort of blunt force trauma sustained by Mr. O'Keefe. He ended up on the lawn and he succumbed to his injuries because of the cold and hypothermia. What brought him there, I do not know. Other than Karen Reed and John O'Keefe came to 34 Fairview. And then from there, what happened and what transpired, I do not know, other than John O'Keefe died and Karen was able to drive home and then ultimately came back in the morning.
Yep.
So again,
that's reasonable
I don't
doubt.
have clear vision.
Yeah, that's reasonable.
Yep.
Ronnie and Stanislaw, amazing. Thank you so much. Thank you for your service and thank you for shedding a lot of light on what has really become a very divisive and confusing case. Ronnie and Stanislaw from the Karen Reed jury. When we come back, something else you need to know tonight.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
An Iowa man is found unconscious after crashing his car. He asked police to check on his girlfriend, recalling flashes of violence. Now he's on trial for her brutal murder.
The Visions of Violence murder trial, weekday mornings on Court TV.
Time to reveal something else you need to know tonight. Taking a look at the big...
My bad. All those people outside the courtroom yelling and screaming, they're supporting Karen Reed.
Board guilty on all counts. That's Marcella Chichester from the birthday party murder trial, convicted of killing 8-year-old Alana Phillips and her 4-year-old brother, Zane Phillips. Her sentencing will be scheduled for May 15th. Those charges include second-degree murder, an emotional day in court, but justice was served. Please take a look at your screens. We have a missing child who needs your help tonight. This is Amaya Dillman. Amaya missing out of Maricopa, Arizona, just 16 years old. If you see Amaya, please pick up the phone, make a call, make a difference. You can call 911. 1-800-THE-LOST, or you can call the Maricopa Police Department in Arizona. We've got that number up on the screen for you right now. Let's see if we can get Amaya to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.
I wonder why court is taking so dang long. They decided to do their lunch break instead of their morning break. Okay. I got you, boo. Okay, so what did y'all think about that juror? I would believe that he's one of the jurors that would find her not guilty. I understand that some of the jurors really wanted her to be charged with something because she was drinking and driving. I don't think that's a good way to look at it. You look at the charges. Can you meet those charges? Is there reasonable doubt? There was. Done. You know, I think it's so easy for us to lose sight of what reasonable doubt really is. And if you have any doubt in your head that any reasonable person would have under the evidence, then you can't convict. As much as you may want to. As much as you may want to. So I don't know. It's a sad situation all the way around because in the end, justice for John is not going to happen. It's not happening now. Even if Karen Reed is found innocent, we still have a victim that has not been brought to justice. And unfortunately, may never, because of the type of investigation that's been done. Now, the federal investigation does not mean that the people inside that house unalived him, even though it's no longer happening at this time. But doesn't mean that it's totally closed. They can reopen investigations, and we'll see how this trial brings forth that it didn't the first time. But I will tell you that after hearing this investigator talk about what he learned, unattached, he's like us. The gentleman is not a part of any of the case. He's a private investigator. He did his digging. What he found versus what is being presented is a little bit interesting. After the trial, because I don't want to do it until after the trial. When the trial is done, I will bring that information forward in a video for us to watch. But I want to go through this trial before I do, because I don't want it affecting everybody's opinions. I want you to listen to the trial yourself, come to your own conclusions, and then I will give 100% mine. Even though I do. Oh, sorry. Even though I do have an opinion and you think I get it, I give you bits and pieces, but I'm trying to stay as neutral as possible in my position, which I guarantee you is not an easy thing to do. I have some things that I can sit here and say that are prosecution. I don't believe in supporters. I believe in getting to the truth. Congratulations, you're on board with us. But I do believe that if you are a supporter and you do believe that what is being said is the truth, then I'm all for it. My mic thing is driving me crazy and I can't fix it. Every time I try to set it, it loosens because I can't, let me show y'all. Y'all can't see the joint. There's a joint right here that y'all can't. Seriously, my favorite mode disappeared. Are you freaking kidding me? There we go. Well, it's right where my name is. God bless America. That joint right there, I can't get tight enough. It wiggles. And it's hard for me to set my microphone where I want it because every time I do, it just wiggles. Ugh, is what it is. I'll need to manhandle it later. I'll manhandle it a little later. Okay. Okay. I got some new features I got to figure out here. Toxic, I just read your thing. Sounds like a plan. Thank you very much. For those of you who do not know, Toxic is our mod boss. She is fabulous. Karen Reed's defense team. Let's see. I want to watch some of the lawyers talk about the decision the anti-Bev had to keep out Aidan Kearney's attorney from being on Karen Reed's side. They got some interesting points of view, but I really want to go back to this and talk. We saw the picture in the interview where only part of this tail light that was there was, oh, sorry, wrong part, was this little upper corner that you see here. And then all of this was gone. And then you have that little white section. Well, like again, when I say here, I don't know. I don't know. What are your thoughts on it? What do you think? Is the tail light? Do you believe the tail light was broken at the scene, or do you believe it was broken when she backed up in him? I don't believe in supporters. I don't believe in truth. I'm going to get to the truth. I agree with you, but I believe that it's okay to support somebody. If you believe in their truth and you want to support them, that's fine. But I don't base my decision on whether you're being truthful or not on the number of supporters you have outside that window. It's all evidence based. And that's how I feel. That's how I feel. Okay, let me get. Oh. Okay, I'm sorry. I'm getting rid of some. I got a bunch of stuff that just popped up in Discord I had to get rid of. Not get rid of, but look at. Everybody is talking about the bedrow conflict. The interview with Lori Vallow, I cannot seem to find the entire. I need to bring this forward so I'm looking at the camera and not sideways. I cannot find the entire Lori Vallow interview. Not pieces of it, but the entire video. They keep talking about it. I thought it was supposed to have already run, and it didn't. It hasn't dropped. They're piecemealing it, which is driving me crazy. Oh, here, well, there's 30 minutes there. It was an hour-long interview. Oh, he's talking about it. I might show that in my Discord. Because if I can find the full length version of it. because Keith Morrison on Dateline did the entire video. But I can't find the entire. If anybody can find the entire video, not the clips of the video, that would be great. I can't find it. I'm looking. Because I would love to be able to have that on Discord and us watch that. Because what I've seen of it thus far, that woman is bat crazy. Can't find it. Congratulations, June. You did it. You got me in a private message. Woohoo. All of my mods, everybody, please go to Discord, go to member chat. There's an important chat that you need to see. Thank you so much. If you guys are having problems in Discord, please let me know. I'll be happy to help you off camera as we can set up a time. But anyway, I cannot find the interview. So if anybody can find the full Lori Daybell interview, airs on Dateline. It should have already aired. I'm not going to pull it up here because I don't want to get a copyright strike. Everybody's going crazy over the denial of Mark Bedrow. Everybody's going batshit crazy. So, state employees in Texas are being instructed to return to the office. Woohoo! Get back to work, y'all. Get back to work, 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 work. I'm looking. Forgive me if I'm a little quiet. I am really trying to find it. Okay. So in this trial that we have been watching, they should be returning any minute. Are you kidding me? They're taking one hell of a long lunch. Roommates mess. Let me go find another trial for us to watch because I can't. Oh, I can watch Channel 12 News. Can't I?
We have seen
Why
a
not
lot about
here?
Lori Vallow over the years, but for the first time, the so-called doomsday mom sat
Why
down
do
for
I
an
not have
interview.
that?
She did it with NBC's Dateline.
Can y'all hear
She's
this?
doing life without parole for, among other crimes, the terrible murders of her 2 children in Idaho.
And now she's at the Estrella jail in Phoenix, awaiting a conspiracy to commit murder
I don't
trial.
know.
12 News journalist Erica Stapleton is here with more on that
Why don't you
jailhouse
have
interview.
sound?
Erica?
Yeah, Tram Troy, this is the first TV interview with Lori Vallow behind bars. It is extensive and often combative. But before we get to that, let's give you some
I'm gonna let
background.
this run
Back in
till I
2023,
figure
Lori
out the
Vallow
sound
was
issue.
sentenced to life in prison.
All right, that's not giving me sound. Let me go back and make sure it's not just them.
Receive insurance money.
I knew it.
I'll allow this question.
I knew it was going to be
That sound
involved
over here either.
in some way, shape, or form.
Give me a minute.
Prior to leaving to go to LA. Right? Isn't that what you said?
Yes, sir.
There we go.
That's when you were told about the possibility.
I don't know why that happened. I gotta find that again. There we go. Channel 12 News. I can do.
We have seen a lot about Lori Vallow over the years, but for the first time, the so-called doomsday mom sat down for an interview. She did it with NBC's Dateline. She's doing life without parole
That's
for,
on
among
them.
other crimes, the terrible murders of her 2 children in Idaho.
often combative. But before we get to that, let's give you some background. Back in 2023, Lori Vallow was sentenced to life in prison in Idaho for killing her children, Tylee and JJ, who used to live here in the Valley. In Arizona, she's facing 2 conspiracy to commit murder charges, one out of Chandler in the death of her former husband, the other a shooting attempt in Gilbert at her niece's ex-husband, who ultimately wasn't injured. The trial in that Chandler case is set to start later this month, and it's been a long time coming. Lori Vallow has been locked up in the Estrella jail here in Maricopa County since late 2023 after her conviction in Idaho. Her husband, Chad Daybell, was also convicted in the Idaho case and sentenced to death. She will be representing herself here in Arizona at her upcoming trial. Here's part of that exclusive interview with Keith Morrison.
Chad was convicted and he's on death row now.
I understand that, yeah.
But
They have some
how could
fascinating
you
stories.
possibly think that Chad would be exonerated
The
after
same
what
way-
happened?
The same way I will be exonerated. We will both be exonerated in the future.
Because
I have seen things in the future that Jesus showed me when I was in heaven. And we were not in jail. And we were not in prison. And they were still in the future from now.
So let's take a legal deep dive. Defense attorney Hector Diaz joins us once again. Hector, obviously you saw that. How could they both be exonerated?
You know, I think what she's referring to is this whole Idaho matter, right? She was convicted, life without parole. And I think what she was referring to is, you know, hey, we're going to be exonerated. And, you know, maybe to the extent she's talking about the Arizona convictions, I mean, she hasn't gone to trial.
Yes, Dateline tonight.
She's optimistic and has agreed to the interview with Keith Morrison. So,
Which I was going to say, if she was your client, would you ever allow her to do a sit-down jailhouse interview?
no, I would run for my office to stop it. To stop it. Absolutely.
Yeah.
And if she wanted to proceed.
Okay, that sucked. And then let's say we agree to disagree. I still like you though. Yeah, I get it. I will say, when it comes to this group of supporters, I feel it's gone a little too far. I feel there's ways to show support. And if you want to stand out there and say, Karen Reed, whatever, that's up to you, boo. But I do believe that some of the support has gotten to be a little out of control. And but I mean, y'all, if she didn't have that support and you believe she's innocent, how much of this do you think she is going to be able to survive emotionally if she didn't have those people out there? She said many times that these supporters are the ones that have gotten her through a lot of stuff. And knowing that when she comes out after having a really hard trial and being hammered like the other day, having that support and those cheerleaders that you don't know can mean the difference of how you handle things. I wouldn't be out there. I'm supporting people here, but I wouldn't be out there. I don't know. People do what they're going to do, and that's what makes us, I mean, it makes us unique, and I can agree to disagree with you. Not that I don't agree with you. I'm just saying each to his own. But I do believe that Aiden Kearney, as much as he supports her, I think he has said some things that have hurt. And I think that have gotten himself in trouble the other day in his hearing, where they said that there is new evidence of him outside of the pizza place, looking in, saying things through the window. That was stupidity at its best. And you can sit there and say all you want, free speech, but you know, there's ways to do things without antagonizing the lion. And if you antagonize the lion, you're going to get bit. And I'm not saying he deserves everything he's going through by any means, but what I am saying is sometimes you reap what you sow. And some of the stuff he has said is not so much about Karen Reed, but the language he uses and the way he says things is very disconcerting. He uses the "see you next Tuesday" word so freely and without any reservation, it makes my skin crawl. I am not a huge fan of his. Do I believe that some of what he says as in what he does is in line with what should be done? Yes, but not much. Do I appreciate his support of Karen Reed? You betcha I do. But his mouth is one of the worst potty mouths. And listen, I'm around some potty mouth people, and I thought I couldn't blush. He can make me blush. And I don't understand why it's not okay to use the N word in public, but it's okay to use the "see you next Tuesday" word. I don't know. I just can't handle that. I can't handle the fact that he tells people to I'm not gonna repeat it. It's just horrible. And I think that you are antagonizing the beast. And you can agree or disagree with me. There's another lawyer that I think is a good lawyer, very good lawyer. But some of the things he said and the verbiage and the vocabulary in which he uses turns me off. And that's okay. Each to his own. But I will not put that on my channel. I mean, I put some of Turtle's voice stuff on, but let me tell you, it's very screened before I do. Because his language is the roughest I've ever seen on YouTube. But then again, my YouTube channel, what I surf on my YouTube doesn't have that kind of stuff. So that's the way it is. You're going to get a lot of beating. If you looked at my YouTube channel, not my channel, but my browser, you get a lot of Native American beating, court documents, court stuff, but you don't get anything that deals with people who say those words. You'd be pretty bored with my YouTube. You'd be pretty bored. In the Sementilli trial, where do y'all stand? I'm ready for them to get to the defense. I was kind of hoping they would bring on the lover. I want to see an ex-pone star. I want to see what he looks like now. Oh my gosh. You can't make this up. I mean, he's an ex-porn star. And she was acting like trying to be one at 50 years of age. She's my age. Oh, I would like to have her body, but I'd rather have my mind and wisdom over body. Because let me tell you, how far did that get her? What's popping up on X? I'm looking on X. Everybody's posting that. Oh my gosh. Okay. I don't care. This is not politics, but it's funny as hell. Okay. Funny as hell. And I'm not against or for the president, but this is funny. Trump sandwich, white bread, full of bologna with Russian dressing and a small pickle. Oh, Lord. That's bad. That bad. Every president's had bad jokes about him, so don't worry. Oh, so you guys know Elon Musk had they've been having a lot of problems with the rockets, but they also just had some successful recovery. That's cute and oh, I wish y'all could see this. Let me see if I can share it. Give me a second. I have never seen such a thing. I want you to see this. Let me get everything together. Let me get it together. Do I have it up? Yes, it is with camera number 2. Watch this, y'all. I'm going to put it on big. Give me a minute. Watch this. This is at a concert. Everybody is attacking this one woman trying to pull off her wig. What in the hell? Fight of the century. What? They're beating the hell out of this girl. What? Holy hell. Y'all, that's insane. All those people just got up. Look at this. It's very fancy. It looks like it's some kind of award show or something. Anyway, okay, guys, I'm going to have to take a personal break. We are going to go. I'll put this back on just in case it comes back on. And we'll be right back. It should be coming back any minute now. Okay, here's your funk. Personal break. Be right back. was hoping they would be back by now. Look, I got sliced me some apple. Trying to be healthy. Mm. Mm. That fight was insane. Yeah, I agree. Um, I I don't have enough evidence to convict Karen Reed. That's my problem. Everything is too circumstantial. There's a lot of witness testimony that's not consistent. Oh, man. So, did y'all hear about a little boy who wore a police uniform to submor um, to support the Secret Service? He had a costume on, and he got beaten up for it. I'm like, "Seriously? Now we're beating up kids for wearing a costume?" That's insane. Absolutely insane. So, what I wanna know, I thought we had a court date for Karen Reed today. It was my understanding a while back, I guess they changed it. Now, the 18th and 19th, we have a hearing for motion in limine for final trial, and then trial on the 1st. By the way, I read it to you yesterday. That they, are already signing the rooms for the jury selection in court. And that's fine. I'm trying so hard to eat healthy when all I want is a thing of mashed potatoes. So bad. I haven't met a potato I didn't like. Seriously. I have not met a potato I did not like. Oh, Lord. Oh, there's some weird stuff out here. I'm sorry, I'm looking at some pictures of the inverted videos. They are still out? Are you kidding me? They're gonna be out for another hour? Have they been out? Let's go. Okay. hour and 46 minutes, and they're going to be out until 2 their time, which is 4 my time. Okay, we're going to find another trial. Let's go. We got plenty of time. Mm. I'm looking, y'all. Give me momento. One momento. I don't know anything about this, but we'll watch it.
Spell your last name for us.
Where were you headed on April 20th of last year?
I was headed to a birthday party
Where was the birthday party being held?
at the Swan Boat Club,
Have you been to the Swan Boat Club before?
just the night before to help decorate.
What garnered you an invitation? Why were you invited?
I'm the little boy's godmother.
How horrible.
And that was because of your relationship with Kristen Sigler at the time?
Yes.
Do you know what time you arrived at the birthday party?
It was approximately at 2:08 p.m.
And did you come alone or who attended with you?
No, I had my mother, my 3
That is so
children,
sad that he
Jaden,
got
Alana Zane, and my nephew.
so much
Everett
hell for that.
Smuggles.
Y'all, I blame the parents. Children learn their bigotism, their bullying from somewhere. We are not born with those traits. And for that young boy to be bullied and people to try to beat him up, all because of what he did with Trump, is stupid. You may not like me. You may not like that boy. You may not like if I like Trump, which I won't say. You may not like if I like Biden. I will not say. But I will say this. It does not give you the right to bully, to beat me up. What only right it gives you is to move on. And to do this to a child pisses me off beyond all reason.
Once you got to the party, what did you do?
When we got there, we just explored what was all set up. There's multiple tables and games, a bounce house in the backyard, and the kids just roamed around and had fun.
I love cold cucumber.
At some point, did you tell the kids it was time to eat?
Yes.
And you didn't arrive till 2:05, so do you know roughly what time it was that you said it was time for lunch?
It was close by 2:50 p.m. because it was right after Happy Birthday was sang.
Okay. What is the last thing you can remember from the birthday party?
After they sang Happy Birthday, my kids got their food, they were eating, and eventually when they were done within a few minutes, they ate pretty fast. We were going to go outside back in the backyard to go on the jump houses, but I placed a cake pop in front of Zane and Alana so that way they would be able to get one before they all ran out. And that was the last thing I remember.
So you don't remember the crash at all?
No.
After the crash, what's the first thing you remember?
Waking up in the hospital.
Okay. Do you have any recollection of the boat club after the crash at all?
No, just I remember trying to open my eyes and it was black, like I was asleep or something, and I heard like long distance voices. And it was just a few things that I heard, and then that was it. And then I woke up in the hospital.
You don't remember an ambulance ride or anything like that?
No.
The first time you woke up in the hospital, what was your condition?
I love sweet pickle, cucumber,
I was
pineapple.
choking on the
On that
tube
side
that
of
was
the
in
throat.
my throat.
You
And
had a innovation, a breathing tube down your
a
throat?
ventilator.
Apple don't taste good
And
right
then I
after
was
cucumber.
asleep. And then I woke up again.
When you woke up and you were able to assess yourself, what did you realize had happened to you?
Well, when I opened my eyes, I seen I was in a hospital room. And at that point, I didn't have the ventilator down my throat and my wrists were free. They weren't strapped down. And I heard my sister next to me crying. And I asked her, why am I here? And she said there's been an accident. And it occurred to my brain that how I was in a building the last time I remember at a birthday party. And then I freaked out because it hit me, where's my kids at? And then that's when she told me that Jaden was, life flew to a hospital and Zane and Alana were no longer there.
And you're in the hospital.
Yes.
Do you know what position you were in at that time physically?
When she told me, I started to freak out. I wanted to jump up, but I couldn't. I was hooked up to so many wires and machines, and at that time, I didn't feel no physical pain because of all the medication they were pumping through me.
Did they put you back to sleep again? Do you know?
Yeah.
At that time?
Yeah, it's like I tried to scream, and then everything was black again.
At some point when you had an opportunity to gather yourself, were you able to learn what injuries you had suffered?
Yes.
What were those, Mariah?
I had a punctured lung, broken ribs, a broken shoulder blade, a hematoma on my pelvic.
That's painful as hell.
My chin was busted open. My lip was busted open. I had mouth injuries resulting in losing a tooth and nerve damage throughout my face because of my teeth.
Do you know, by the time you were able to wake up and comprehend all this, how long you had been in the hospital under sedation?
I don't know. This is a new one for me.
No, just of what my family told me.
It was days, though.
Do this.
I didn't wake up.
Let me do this and do the read. The mother of 2 children unalived in a crash at Swan Boat Club in Monroe County testified Tuesday. Marcella Childer was charged with 2 counts of second-degree red rum, 2 counts of operating under the influence of liquor, causing death, and 4 counts of OU operating under influence, basically serious injury. So this was a boat where you could have children's parties on it, and they crashed the boat, and apparently 2 children died, and
Up till the
injuries
next
happened.
day
They
after
were her
the
children, and she got hurt.
accident. And I got released from the hospital 4 days after the accident.
When you went home, were you able to walk and move freely?
No.
What kind of impediments did you have when you went home?
I had to use a walker if I did get up. It was very hard to move around. I couldn't get into a vehicle for probably a month. And if I did, it was hard. It hurt severely. I couldn't sit straight up. I couldn't lay down flat down.
Break is
And
better.
it was just rough. I just sat there basically until I healed, until I made progress to move around. And I had physical therapy come to my home to work with me. And then that was helping. And then they sent me to outpatient therapy, and that it helped extremely.
And how long did that all take?
A couple months.
You said that you learned that your son Jaden had been life flighted to a different hospital.
Yes.
How long was Jaden in the hospital?
2 weeks.
When he came home, he eventually came
Oh,
home
okay,
to
so
your
one
house?
came home.
Yes.
Were you able
I don't
to
know the
care for
details.
him?
No.
2 children died.
At the time, how old was Jaden?
He was 11.
He's 12 now.
Yes.
Did Jaden receive any home care? I know you mentioned physical therapy for yourself.
Yes. He had physical therapy, occupational therapy, and then a regular nurse coming to the home.
Okay. Do you know what injuries he sustained?
Yes.
What happened to Jaden?
He had multiple broken bones that consisted of his wrist, his fingers. He had a broken pelvis, his legs. He had a big gash in the back of his head. He also had a punctured lung, broken ribs, and a concussion.
Did he have to have surgery?
Yes.
Do you know what part of his body he had to have surgery on?
His femur, his legs.
He won't play sports.
How long? Well, first I'll ask this way. Jaden's not going to come testify today.
No.
Is Jaden able to walk and get around today?
Yes.
How long did it take for him to be able to do that?
Many months. I can't even give an exact time frame.
Mariah, you were able to bring a photo of Zane and a photo of Alana for the jury to see today. Is that right?
I don't know. She may have 3 kids, but 2 kids passed away.
Mariah, are those your children?
Children killed. So
Yes.
I don't know how many were
No further
killed.
questions, Judge.
Cross.
Oh, poor me, amigo. Oh, poor babies. How horrible. All because a woman went to work drunk and drove a boat. I think it was a boat.
I'm sorry for your loss. I lost my son in September.
Oh, somebody's
He died
crying.
peacefully. It's older. And every time I work on your case, I think you.
He's crying.
And I think your children. You have my deepest sympathy. And I'm human. Might be a defense attorney, but I'm human. And you seem like a much stronger person than me.
It's hard.
My prayers are with you and your family. I wish you the best. People keep telling me God has a plan. I guess that's what we got to do. So I just wanted to come out here and tell you, true heartfelt, that I feel very bad for you.
Is this the defense attorney?
It's a club you don't want to belong to. And I don't have any questions for you. You've gone through enough in life. But
Judge, people appreciate.
I'm done. I'm done. Okay, thank you very much.
No question. He just wanted to express sympathy. And that's the woman charged with unaliving him. I've never seen that before.
Just give me both of those. We'll get them out of the shirt camera shot. Thank you.
Never have I ever seen a defense attorney get up there and express such deep, heartfelt sympathy and condolences. I am shocked. This is the Swan Boat Club trial, jury seated, and the testimony begins. Wow. That is crazy, y'all. Oh, I want to hear this. This is the toxicology testimony
Thank you, Judge.
in this case.
Ms. Beecham, good morning.
Good morning.
What do you do for a living, ma'am?
Currently, I am a supervisor in the toxicology unit at the Michigan State Police Lansing Laboratory.
How long have you been a supervisor?
I've been supervisor since April of 2022.
And how long have you worked in the Michigan State Police Crime Lab overall?
I've been there since October of 2008, so about 16 years. And I started as a forensic technician and then was interviewed and promoted to forensic scientist in August of 2009.
Prior to working at the Michigan State Police Crime Lab, did you have any employment in your field?
Not in my field, no.
What did you do before you worked at the crime lab?
I worked at the plant biochemistry laboratory at Michigan State University.
So it was still in a hard science, it just wasn't in forensic science or forensic toxicology?
Correct.
How long did you work there?
About 6 weeks from graduation till employment at MSP.
Got it. So more or less you started the crime lab right out of college?
Yes.
You mentioned your university. What education did you have to receive to hold your position?
I have a bachelor's degree of chemistry and molecular biology, biochemistry, actually from Goshen College in Goshen, Indiana.
She's a smart kudos to her. Anybody has those kind of degrees, I bow down to.
So your current position, I think you said supervisor of the crime lab, but did you indicate you're a forensic scientist or forensic toxicologist?
Yes, I'm a supervisor of the toxicology unit, not the whole lab, with experience as a forensic scientist in that unit as well.
And do you still engage in the day-to-day duties of a forensic scientist?
Some of them I perform a lot less casework, but I do stay up to date on my proficiency testing, and I'm training other people in doing those analyses at the moment.
Okay. So to do that, do you continue to receive training in your field?
Yes.
And what kind of training do you continue to receive?
So 2 weeks ago, I was at a conference called the American Academy of Forensic Sciences. It's a week-long course. I go to some Society of Forensic Toxicology meetings, as well as the Midwest Association for Toxicology and Therapeutic Drug Monitoring. Those last two I'm members of, and the MAT organization I am a past president of. So I'm involved in researching what I can, presenting at those, and just getting information from others in the field.
Okay. So that type of training, conferences and things like that, about how often do you attend those?
Usually a couple times a year for specific to toxicology training, and then there's always leadership trainings and things like that as well.
So some of them pertain to the day-to-day duties in the lab, and some of them pertain to your leadership role in the lab?
Correct.
To hold your current position, Ms. Beecham, did you receive any specialized training as it relates to performing drug analysis on blood?
Not technically for my current position as a supervisor, but as a forensic scientist, yes. I did a lot of testing other samples that other people have analyzed to make sure that I'm getting accurate results. We participate in proficiency tests, and some of the assays, like the one I will discuss today, I wasn't formally trained in it because I was part of a team that created that. So there's no way for us to get that training, but I am very familiar with all of the steps that we did to make sure that that is a valid method.
And thank you for clarifying and separating between your role as supervisor and your role as scientist. In your role, in order to be able to continue to run tests in the lab, do you have a requirement to continue receiving education in your field?
Yes.
And what is that requirement?
It is, I don't remember exactly how many points, but we have to have a certain amount of points of continuing education, which usually equates to attending the annual toxicology meeting that we put on. Usually we bring in an outside person to give kind of a technical talk at that, attending usually 1 or 2 conferences, and then usually reading a book or literature articles.
And you keep up with all of that?
Yes.
Prior to April 22nd of last year, have you ever tested a blood sample for the presence of drugs?
Yes.
About how many times?
Over the course of my career, I've tested over 40,000 cases for alcohol or drugs, probably about half and half.
Okay. Have you ever been qualified as an expert in forensic toxicology in the state of Michigan?
Yes.
How many times?
I've testified over 185 times, and I've been qualified every time I've been offered as an expert, probably somewhere around 120.
Ms. Beecham, I'm going to show you a document that's been pre-labeled People's Exhibit 21. Could you take a look at it and tell the jury what that is?
There are actually 2 documents stapled together here. The first 2 pages are my CV, curriculum vitae, and the second 2 pages are those of Diane Bennett.
Well, that's a mistake. Thanks for catching that. The first 2 pages are an accurate reflection of your experience in the field.
Yes.
Judge, people would move to admit this as People's Exhibit 21 minus the extra pages.
I'm sorry. No objection, Your Honor. People's 21 is admitted.
Apologize, Judge, I'm just relabeling it for the court.
Okay.
Judge, at this time, I move to qualify Ms. Beecham as an expert in the area of forensic toxicology.
No objection, Your Honor. The court determines this witness is an expert in forensic toxicology.
Thank you, Judge. Ms. Beecham, were you working at the crime lab on April 22nd of last year?
Yes.
And did you receive a blood specimen that brought you here to testify in this case?
Yes.
How, through the course of lab protocol, did you come to receive it?
I came into contact with it as our laboratory, once a sample needs a certain kind of test, those just kind of sit in our computer system. It was my turn to do one. So I pulled a batch of cases, and this was one of those.
Okay. And is that case somehow identified by name or number?
Yes.
And what name was associated with this sample?
We use a laboratory number mostly through our system. And then also as we're going through looking at the evidence, we make sure that the laboratory number matches the name that was on that paperwork.
And the number assigned to that sample, what name did it match?
It was, I'm probably going to butcher the name, but Marcella Chedister.
So when you procure the sample, is that brought to you? Do you get it from somewhere?
I go to our secure refrigerator and then pull out our technicians will prepare the batch together. So I will pull out the samples that I'm working with, check each of them individually, and then perform my analysis.
That's what happened in this case?
Yes.
And do you check the specimens to make sure they're labeled properly?
Yes.
And did you do that in this case?
Yes.
Do you check the samples for irregularities?
Yes.
And did you do that in this case?
Yes.
Did you locate any?
No.
Did you follow all of the applicable protocol for this sample?
Yes.
So after you received the sample, or procured the sample, I should say, made sure it was properly labeled, documented, in good order, what did you do then?
Then I did an extraction on the blood called a protein precipitation. So I take a small amount of the blood and I put in acetonitrile, which is an organic solvent, and that basically makes all the proteins clump together, and put it in the centrifuge, and I take off the liquid that's on top of that. A small amount of that, then that is in the acetonitrile still, which can't go on our instrumentation, so that gets dried down, and I reconstitute it or redissolve it into something that can go on our instrumentation. So I did that and then ran it on the instrument with calibrators and controls, processed that data. It was reviewed by another analyst and then prepared a report.
Okay. So is that the typical method the Michigan State Police Crime Lab uses to test samples of this kind?
Yes.
And you previously testified to it, but you guess you've done this about 20,000 times?
Each drug test is a little bit different. I'm not sure exactly how many of this particular type I've done, but in general, yes.
And all of those tests you performed, they were at the Michigan State Police Crime Lab?
Yes.
Outside of what you've described, does the lab have any protocols in place for this method?
We have different protocols that are things like quality control assurances, are making sure we comply with accreditation requirements. But the specifics about how the sample is tested is what I testified to.
Okay. Beyond what you've already described, is there anything to add about the method and modality that you use to analyze this sample?
We use I didn't speak about the instrumentation, which we use LC-MS-MS, which is liquid chromatography mass spectrometry. Basically, that is a system that the chromatography part will separate the different components that are in that blood sample, and then the mass spectrum helps us to identify what it is.
Can you explain as best you can to people who know nothing about chemistry how that works?
Which part of it? Or all of it?
I guess enough to make folks understand what it is that you do makes sense to us in the real world.
Sure. So the chromatography part at the beginning, basically it's a tube, and in that tube is some little particles, and based on what the shape of the molecules are that we're looking for, they're going to interact with those molecules in there differently depending on what it is. So it kind of just travels through there in a liquid, and then the detector part at the end basically shoots some electrons on it, and then you end up with a mass spectrum, which is a kind of a fingerprint. So if a particular compound gets bombarded with electrons, then it's going to split up into pretty consistent pieces each time. So we're looking at like the comparison of what those pieces are.
Okay, thank you. Do you know when you performed the analysis on this sample?
Do we
On
do we
April
still not understand?
25th, 2024.
And when
Nice
you
try.
perform an analysis of this nature, are there procedures to verify the accuracy of the result?
Yes.
And what are those procedures?
Oh, that's
The
good,
first thing we do
June.
is the beginning of the run is what's called a calibration,
Thank you for
which
the
basically
update.
teaches the instrument what the different levels of that compound are going to look like. And then, so that's the first 6 samples. We run a negative to make sure that there's nothing in our system that is producing a positive result when it shouldn't. And then we run some cases, and then about every 10 or 15 samples, there's a control where we're checking that calibration. The controls are known samples that we know what the result should be. And we make sure that we put those in place throughout the run to make sure that we are getting accurate results. So those include 3 positive controls, 1 negative control, and then a control that we actually purchased from another company that comes verified at a certain concentration to make sure that our results are accurate.
And that was done in this case?
Yes.
With the testing of this sample?
Yes.
And you indicated during that answer that all the instruments in this case are previously calibrated?
Yes, I calibrated when I ran my batch.
Okay. And everything when you ran this sample was in good working order?
Yes.
And Ms. Beecham, these methods that you use to test this blood sample, are they accepted in the scientific community at large?
Yes.
And were you able to obtain a result for any drug from the sample you tested for the defendant in this case?
Yes.
Did you prepare a report regarding that?
Yes, I did.
I'm going to make sure I only have one document stapled together this time for you. I'm going to show you what's been previously marked People's Exhibit 22. Do you recognize that document?
Yes.
And what is it?
This is a supplemental laboratory report for our laboratory number TX24-5842 for a subject of Marcella Chittister.
And why is it a supplemental report?
The alcohol analysis is always the first report, so anything after is a supplemental report.
Okay. And is that document dated?
Yes.
And it's April 25th, 2024?
So the date on the report is the date that I wrote the report, which was April 26th. I did the analysis on the 25th, but it runs overnight. It has to be reviewed. It takes a day.
Okay. And you signed that document?
Yes.
And does that meet the criteria for reporting for the admit Exhibit 22 supplemental report prepared by Samantha Beecham?
It's fine. No objection. People's 22 is admitted.
And Ms. Beecham, if you could read off your report to the jury what the result was for the drug analysis run on defendant's blood sample.
I detected and quantified gabapentin at 1.3 micrograms per milliliter.
And Ms. Beecham, do you know what gabapentin is?
Yes.
Can you explain to the jury what it is?
Yes, it is a medication that's often sold under the brand name of Neurontin. It can be used for things like seizure disorders. It can be used for pain relief. There's a couple other off the label instructions for things that can be prescribed for, but those are the 2 main ones, seizures and pain.
And what does it have a drug classification?
Yes, it is considered an analgesic, it is a central nervous system depressant, which means that it has the ability to slow down the nervous system.
Okay. If I could grab Exhibit 22, that problem.
Thank you, June.
And clinically, Ms. Beecham, can you say whether gabapentin has any noted interactions with alcohol?
It can. It depends a lot on the individual, their dosage, how frequently they use alcohol and the gabapentin at the same time. But alcohol is also a central nervous system depressant, so it wouldn't negate those effects.
So would it be fair to say that consuming the two together could exacerbate their effects.
Correct.
No further questions, Judge.
Cross?
Good morning, if it's still morning. My name is Bill Kolobis, and I'm the attorney representing Marcella Jones for the defendant in this case, okay?
Okay.
And I'm going to ask you a few questions. You know, when attorneys say that, it's usually, 20, but I'll try to keep it very, very short, okay?
Okay.
All right. And then just keep your voice up for the court reporter and the court to be able to hear you, okay?
Sure.
Thank you. How long was it that you've been working in your role right now?
My current role, almost 2 years.
So at the time that you did this testing that you spoke of, you were doing your job employment-wise for about a year?
As a supervisor, about a year. As a forensic scientist, I've been there about 15.
Okay, thank you. Now, I'm going to just jump around for a moment. You had just said in response to the prosecutor's question that this drug can be used for seizures, correct?
Yes.
And it's a lawful drug as long as you have a prescription and you're not overusing it, correct?
It is a prescription controlled substance, yes.
Okay. And you said it's used for seizures. What else is it used for?
It can also be prescribed for pain.
And then you didn't have anything to do with putting any preservative or any particles, substances in the tube prior to the blood going in the tube. Have you had anything to do with that?
No.
Does a company do that, or does the state of Michigan do it?
We contract with a company, and then every time they send us a shipment of those boxes, then we get a certificate of compliance that they put those in there.
Okay, so a private company does.
Yes.
You don't have anything to do with checking the standards or things like that. You just strictly toxicologist, you do the testing.
Correct.
And the sample, or excuse me, the amount that's given to you or the sample of blood is only as good as the sample it is. Your test is only as good as that, correct?
Yes.
And if there's a flaw in the blood that's given to you, then do you agree that your test results are your results, but they're not accurate?
Depends what the flaw might be. A lot of things, it depends what the flaw would be.
Some are serious flaws, some are not, right?
Correct.
Okay. Why do you, you said that before you tested this sample, excuse me, on the 25th of April of 24, where did you get it from? Where was it?
It was in a refrigerator.
Why?
Okay, why is it in the refrigerator?
We keep things in the refrigerator for two reasons. One, it slows down if there is any growth. We keep all of our evidence in there. So urine bottles are not preserved at all. So we keep everything in the refrigerator in case there's any growth of bacteria. It will slow that down, and it also slows down the degradation or the decrease of different drugs that we may be looking for in the future.
Does it slow down? I use the word fermentation too.
It can if fermentation were even happening.
And you said, and that's interesting, urine, a urine sample does not have to be refrigerated.
It is refrigerated. It does not have any preservatives in the bottle.
Okay. And the blood is supposed to have preservatives in the tubes?
Yes.
And there's two tubes, correct?
Yes.
Okay. And then you did a test on this, correct?
Yes.
On this blood that you spoke of with the prosecutor, right?
Yes.
Okay. And then it had a result of what?
It was 1.3 micrograms per milliliter of gabapentin.
For us now not scientific people, what would be micrograms per milliliter?
It's just a concentration that we use. So a lot of drugs are nanograms per milliliter, which is a billionth of a gram. This drug is such that we report it in micrograms, which is a millionth with an M of a gram.
So when you check the concentration of it and you say 1.3, if it was nanograms, it would be 1.3 billion, correct?
If I were reporting my result in nanograms, it would be 1,300 nanograms per milliliter.
It's a minute amount if you check that, correct? If you went by that scale.
I went by the scale that I measured. So it's a concentration.
Okay. So if you go by 1.3, and the UG stands for what?
Micrograms,
And the ML stands for what?
milliliters.
Okay. And micrograms, again, at least so I can understand it, micrograms is, what's the millionth of what?
It is one microgram is 1 millionth of a gram.
1 millionth of a little tiny gram.
A gram is actually like a handful.
And it's 1 millionth of that.
Yes.
I didn't know a gram was about a handful. I thought it was much smaller. Interesting.
And you never interviewed my client, am I correct?
Correct.
Why would she?
And you never saw my client at all. You said you never interviewed her, but you've never seen her, would you say, other than today?
Correct.
You never sat down and talked with her and asked her any questions?
I have not.
Yeah, I think
No
that's
reason to.
fair.
I've been pretty good, Judge. Did you get a chance to talk with the prosecutor or anybody from their office prior to today?
Yes.
When did you do that?
I'm not sure the exact day. It was one day last week.
Okay.
Maybe Wednesday.
And you didn't talk to anybody prior to that?
I don't think about anything specific. I may have, told them that I had a subpoena. I was supposed to be at a training this week, so we discussed logistics, those sorts of things.
And were you moved to today instead of another day this week?
I believe I was always going to be today.
And you and the other toxicologist, you both drove up here together? Did you, and then I'm going to ask her a follow-up question. It's just, did you drive up here together from Lansing? Drive down here?
I'll take the answer. I'm not sure how relevant
Thank
it
you.
is.
Did you drive together from Lansing today?
With Ms. Faust, yes.
Did you discuss your testimony?
And, okay. Did you discuss court at all today?
We discussed logistics, who was going to testify first, what we had with us. I haven't seen her much since I've been out of the office. We didn't discuss specifics about this particular case or what we would testify to.
That's a professional witness. She knew exactly where he was heading.
Redirect, very briefly.
Yes, she did.
So
She knew exactly where that was
just,
going.
stupid math question. 1 millionth of a gram is the kind of the number
Hot,
that
cold,
Mr.
hot,
Globus
cold.
said, but that's for every single gram in the body. Is that right?
Correct.
He asked you some questions about the cold storage at the lab, and you gave an answer that just in regards to fermentation, if any fermentation was happening. Could you expand on what you mean by that?
Yes, every sample is not going to be fermenting. So if fermentation were happening, if you're going to make wine or beer, that needs to not be done in a refrigerator. And that will slow down that process significantly. So if there were fermentation happening, you would want it to be slowed down in a refrigerator, but not to say that it was in this case.
Okay. No further questions? Any requests? Just 1 second. I don't have any other questions. All right.
Okay. I thought they were going to tell us more about her alcohol levels.
Well, get cases every year, unfortunately.
Jarrell, the gas company in New Mexico, they also did an analysis of the residents, and they found one minor leak in a single burner on the kitchen stove, which was 0.33% of room air, which was pretty minute and insignificant. Since that time, Xena, the deceased dog, has been taken for necropsy at the Veterinary Diagnostic Services, and we'll be awaiting those results. Let's speak a little bit in reference to the timeline for Betsy Arakawa. We know from our investigation that on February 9th, 2025, she picked up Xena from Gruta Veterinary Hospital. There was a procedure that was done with the dog, which may explain why the dog was in a crate at the residence. Let's move on to February 11th, 2025. Mrs. Arakawa had an email conversation with her massage therapist at about 11:21 a.m. Moving on into the afternoon, Miss Arakawa was at the Sprouts Farmers Market between 3:30 and 4:15 p.m. Miss Arakawa was seen on surveillance video at the CVS pharmacy in Santa Fe from 4:12 to 4:20 p.m. She then stopped at a local pet food store at about 4:54 p.m. Her car was seen on surveillance, and the remote control clicker that is assigned to her and her vehicle was used to enter the subdivision to gain access to the gated community at 5:15 p.m. Numerous emails were unopened on her computer on February 11th. There was no additional outgoing communication from her or known activity after February 11th, 2025. The cell phone information and the cell phone data is pending. We're working with state police to get the information from those phones, but our investigation shows that all the last known communication and activity from Ms. Arakawa was on February 11th. I'm going to go ahead and turn over the podium to Dr. Gerald. I would ask that everybody refrain from asking questions until everybody has provided their statements. I'll step up to the podium, and then we'll go ahead and field questions from the media. Thank you.
Good afternoon, and thank you for being here. I'm Dr. Heather Gerald, the Chief Medical Examiner for New Mexico at the Office of the Medical Investigator. I'd like to begin by stating that it is unprecedented for the Office of the Medical Investigator to make public statements about death investigations. However, the circumstances surrounding these two deaths require accurate dissemination of important information. I've also spoken with the Hackman family prior to this conference, who are aware of the autopsy findings and conclusions and are aware of this conference. On Thursday, February 27th, I performed an autopsy on Mr. Gene Hackman. Medical examiner Dr. Daniel Gallego at the Office of the Medical Investigator performed a full autopsy on Miss Betsy Arakawa Hackman. also on Thursday, February 27th. By report, Ms. Arakawa Hackman's legal name is Betsy Hackman, which is how she will be referred to hereafter. The cause of death for Ms. Betsy Hackman, aged 65 years, is hantavirus pulmonary syndrome. The manner of death is natural. Autopsy examination and full body postmortem CT demonstrated no findings of trauma internally or externally, with microscopic findings consistent with hantavirus pulmonary syndrome. Laboratory testing was positive for hantavirus at a clinical lab, with required confirmation testing positive at Scientific Laboratories Division. Testing for COVID-19, influenza, and other common respiratory viruses was negative. Testing for carbon monoxide was negative. There were no other significant natural disease findings. Pills present on scene were thyroid medication, which were being taken as prescribed and is not currently a concern for a contributory cause of death. The cause of death for Mr. Gene Hackman, aged 95 years, is hypertensive and atherosclerotic cardiovascular disease, with Alzheimer's disease as a significant contributory factor. Autopsy examination and a full body postmortem CT examination demonstrated no acute findings of internal or external trauma and showed severe heart disease, including multiple surgical procedures involving the heart, evidence of prior heart attacks, and severe changes of the kidneys due to chronic high blood pressure. Examination of the brain showed advanced Alzheimer's disease, as well as blood vessel changes in the brain secondary to chronic high blood pressure. Laboratory testing performed at Scientific Laboratories Division was negative for COVID-19, influenza, and other common respiratory viruses. Testing for hantavirus was negative. Testing for carbon monoxide was negative. Additionally, there were no autopsy findings concerning for hantavirus infection. I have been asked when death occurred for these individuals. There is no reliable scientific method to accurately determine the exact time or date of death. Mr. Hackman's initial pacemaker data revealed cardiac activity on February 17th, with subsequent pacemaker interrogation demonstrating an abnormal rhythm of atrial fibrillation on February 18th, which was the last record of heart activity. Based on this information, it is reasonable to conclude that Mr. Hackman probably died around February 18th. Based on the circumstances, it is reasonable to conclude that Ms. Hackman passed away first, with February 11th being the last time that she was known to be alive.
And he has Alzheimer's, so he wouldn't know what to do.
Clinically, hantavirus infection is characterized by flu-like symptoms consisting of fever, muscle aches, cough, sometimes vomiting and diarrhea that can progress to shortness of breath and cardiac or heart failure and lung failure. This occurs after a 1 to 8 week exposure to excrement from a primarily particular mouse species that carries hantavirus. The mortality of hantavirus, the mortality rate of the hantavirus strain in the Southwest is about 38 to 50%.
Oh my gosh.
The hantavirus strains in the United States are not transmissible from person to person. And so this is an appropriate time to segue to Dr. Erin Phipps, the state public health veterinarian with the New Mexico Department of Health.
So
But
she
before I
passed away
do so,
first.
I'd like to kindly ask for everyone to please respect the privacy that Mr. Gene Hackman, Miss Betsy Hackman, and their family and friends deserve. Thank you.
So he's got latent he's in full blown Alzheimer's. So he probably didn't know what to do. So she was laying there dead for a few days. But where are the caregivers? Wouldn't he have had a caregiver coming in and help? I don't know. That's sad. She probably died first and then he died.
Thank you, Dr. Gerald. I will now provide additional information about hantaviruses in New Mexico. There are many different types of hantaviruses found worldwide. These viruses are zoonotic, meaning they are transmitted from animals to humans. Hantaviruses are carried by rodents. The hantavirus found in New Mexico, the Sin Nombre virus, is found throughout the state, primarily in deer mice, but in other rodents as well. Hantavirus pulmonary
Don't mess
syndrome
with
is a
wild
rare
animals.
disease caused by hantaviruses, but a small number of human infections are found every year in New Mexico. Over the past 5 years, New Mexico has confirmed between 1 and 7 hantavirus
How
infections in
horrible.
humans each year. Through the end of 2024, we have identified 136 infections over the past 50 years in New Mexico residents, 5 of these in Santa Fe County. This is a serious disease. 42% of these infections here in New Mexico were fatal. Most transmission occurs around the patient's residence or workplace, and the New Mexico Department of Health typically conducts an environmental investigation at the residence of all hantavirus cases in our jurisdiction. This can help identify specific areas that may pose higher risk, providing insight into where transmission may have occurred and how to prevent future infections. On March 5th, the New Mexico Department of Health staff conducted a risk assessment of the property, including the main residence, as well as other structures on the property. This was critically important to address concerns about health risks to first responders, as well as to inform any prevention measures needed to protect the family and other individuals entering the property in the future. We assessed the risk of exposure in the primary residence as low, similar to other well-maintained houses in New Mexico. We did identify signs of rodent entry in other structures on the property and provided information and resources about reducing the risk of hantavirus transmission related to those areas. Hantavirus can be transmitted to people through rodent urine, droppings, or saliva, so it is important to take special steps when cleaning up after rodents. Avoiding contact with or breathing in aerosolized rodent
Haley Mouse.
urine or feces,
I knew that was
especially in a poorly ventilated area, is
Love
key.
you.
Detailed
Good night.
guidance can be found on the New Mexico Department of Health and the CDC websites, but I will provide a very brief summary now. It is important to use gloves and a well-fitting N95 mask when around or cleaning rodent-infested areas, and to open any windows or doors for at least 30 minutes beforehand to increase ventilation. Spray the area thoroughly with a 10% bleach solution or a commercial disinfectant. Let it sit for 5 minutes. Next, clean the area with paper towels, then throw them away in a covered garbage can that is regularly emptied. Before removing gloves, wash your gloved hands with soap and water or with a disinfectant, and then after removing gloves, wash your hands again with soap and water. It's important to never sweep up or vacuum mouse droppings, since this can spread particles up into the air. Since hantavirus is found throughout New Mexico, awareness of these risks and how to reduce them is important for all New Mexicans. The New Mexico Department of Health extends our deepest condolences to the families and friends during this difficult time. Thank you.
Thank you. I think that'll conclude the statements for today. We will go ahead and take questions. I ask that there be one question per agency, and please state who you're directing the question to, as there's several individuals here at this conference. Sir.
Sure. Just to clarify the timeline here, does this mean Gene Hackman was likely home with his deceased wife for a week before he passed away himself?
Yes, I would assume that is
You
the
need
case.
to repeat the question. It's not being heard.
Mr. Hackman was able to to live on his own and survive for those 7 days?
I think that's more a question, maybe for Dr. Jarrell.
Just so that everyone, just to repeat, so that everyone could hear the question was, do we believe that Mr. Hackman was able to live on his own and survive? The answer to that question is that Mr. Hackman showed evidence of advanced Alzheimer's disease. I'm not aware of what his normal daily functioning capability was. He was in a very poor state of health. He had significant heart disease, and I think ultimately that is what resulted in his death. I was able to look at fluid to determine if he was dehydrated, and I did not see evidence of dehydration. I did see evidence of very poor kidney function, and I think he died as a result of his heart disease and with Alzheimer's being that contributing factor.
What about starvation?
The question was, what about starvation? So there was no food in his stomach, which means he had not eaten recently, but he had also no evidence of dehydration.
So based on your understanding of the progression of the Alzheimer's, do you believe that he was possibly not aware that his wife had died, or didn't know what to do in that situation?
It's difficult to answer. The question was he aware that Miss Hackman had died? And I think that question's difficult to answer, but I can tell you that he was in an advanced state of Alzheimer's, and it's quite possible that he was not aware that she was deceased.
This is for the sheriff. Considering the circumstances under which Mr. Hackman was found in the mudroom with his walking cane and sunglasses by him, do you think there is a possibility that he was trying to get help for his wife?
That's hard to answer. Again, it's hard to get into the frame of mind of what was happening at the time. And I don't know if we'll ever have the answer to that question, whether he was going to go for help or he wasn't. Sir.
Are there any other big questions that you're trying to answer? I mean, does this answer the biggest question?
Any other real questions?
Is there anything else that you're really seeking?
Yeah. So the question is there any other big questions that are left? I think a lot of questions were answered here today. I think there was, Dr. Jarrell went over the cause of death, and I think a lot of those questions are answered. I think the timeline that we've been given as far as the pacemaker results and the history and evidence that we found as far as the timeline of Miss Arakawa, I think a lot of the questions have been answered. We are waiting on the cell phones, but I would very unlikely that the cell phones are going to or show anything else. Another question?
Sure. Are there any signs of, what have you learned about Mr. Hackman's communication after February 11th? Did you talk to any friends of his who had spoken with him during that week-long period, or know anything about what he was doing?
So the question is whether there was any communication from Mr. Hackman or activity, and no, at this point, no. I don't know if he used cell phones or technology or emails. There's no indication of that. So right now there is no activity from Mr. Hackman.
Sheriff, do you know if his pacemaker was connected to some sort of monitoring system? Does anyone take off that something was wrong?
The question was his pacemaker connected to a monitoring service? The answer to that is that
she's got to be careful. There's still HIPAA.
One of his physicians had contacted me and told me that they could see the data from the 17th, but that to really get the most information from that would come from the interrogation of the pacemaker. And that's as much as I can answer, not being a cardiologist.
They didn't say whether or not they were monitoring, or was his pacemaker equipped to send back data in the exact time so that someone could say, hey, something's not right.
I can't answer that question. I'm sorry.
There's so many questions that people ask that are so.
Was there any footage that came from the body cam from the house?
I'm sorry, what was?
Was there any footage or anything that you can see from, like, body cam footage from the house? Any
Are you talking about the body cams that the investigator, the responding personnel were wearing?
Video, is there any video
No, there was no outside surveillance or interior surveillance that we are aware of in the residence. So there was nothing to show the activity inside or outside the residence, and not at this time, no.
Dr. Terrell, you mentioned that one of the symptoms of hantavirus is shortness of breath. We learned before that Betsy Hackman was laying on the floor when she was found. What kind of medical episode would she have had to cause her to fall and then not be able to ask for help?
The question was regarding shortness of breath with hantavirus and what kind of medical episode would we expect from somebody found on the floor. And I think to be able to answer that question fairly, it can go back to hantavirus infection, which initiates with what's called a prodromal phase. That's initially flu-like symptoms where a person has fever and muscle aches. They don't feel well. After, of course, being exposed to rodent excrement. And that phase can last roughly 3 to 6 days. And then they can transition to that pulmonary phase where they have fluid in their lungs and around their lungs. And at that point, a person can die very quickly, within 24 to 48 hours, roughly speaking, without medical treatment. It's not uncommon to find someone down on the floor as part of a terminal collapse, so to speak. And that may very well have been what happened to
So
Ms. Heckman.
you're estimating her time of death on the 11th, or is it possible that she collapsed and was alive for a couple of days?
Sorry.
It's
They're back. Oh, wait. Wait a minute. Hold on, y'all. I'll let y'all keep listening to this while
It's hard to say. I don't think she was on the floor alive for a couple of days. I think that she went through that time period, and I don't know when she began to feel ill. And those are just things that I don't know that I'm ever going to have
What?
the answers to. But I think, and going back to that initial time period, roughly 3 to 6 days of feeling ill and then succumbing pretty quickly after fluid begins to build up in the lungs.
Given the dog was created, is it fair to assume
Did they stop court for today? Let me watch. I think it went to a different trial.
I don't think we know the answer to that. However, given the timelines presented, it is a possibility.
Is it possible the dog had the hantavirus?
Dogs do not get sick from hantavirus.
Sure.
We may not have any more Sementilli today.
The question was if we knew on Betsy's visit to the pharmacy if there was some medication or if she consulted with the pharmacist. We don't have that information, and I'm not sure.
Okay, y'all. It's almost 4 o'clock. I'm going to call it a day. I'm exhausted from yesterday, happily exhausted from yesterday. Compared to, I had a great time last night. It was amazing. Hold on, let me see what Angela just sent. Yep, we already had that. What did you just send? Wait a minute. Someone just sent me something. I don't know what it is. It's too small. Okay. Guys, we're going to read this. I don't even know what the hell it is, but thank you, Angela. This is, I don't know, toxic. If you'd want this, I'll send it to you. Whoa, whoever got this did a minimum fee of $500. How many pages are there, girl? I got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. We're on page 12. Okay, those two are the same. Okay. I can delete all those. I got that. I got that. Got that. Got that. Okay, so these can go bye-bye. Okay, let me go here. Angela, thank you very much. Yeah, June, I know about the pickles with him. Okay. So these documents, I got to find out where they came from, and if they are not on as the gavel drops, they will be. Okie dokie. Let me move these over here so I can share them in order. That I received them. I don't know if they're in chronological order. Let's go over here. Let's share. Share screen. Okay, guys. I don't even know what this is. Let's discover. Let me see if I can embiggen it a little bit. And I got to do some sizing, guys. I apologize, but it is what it is. Okie dokie. Let me make me a little smaller. There we go. Safe. Safe. All right. Buenas noches from Spain. See you soon. Don't get mad at me for talking like that. I had a good friend that talked like that, and we used to tease each other. Okay, here is the Commonwealth of Massachusetts, William Francis Galvin, Secretary of the Commonwealth Corporations Division, 1 Ashburn Place, 17th floor, ... This is a certificate or organization. The exact name of the limited liability is Expert Data Analysis LLC. The general character of the business is data analysis and any other lawful business in accordance with the Act. Here are the names: William J. Whitfield, Colleen Crawford, and John Fanning. That's what this is all about, y'all. Okay, let me debig in this. Okay. The exact name of the domestic license liability is Expert Analysis, Domestic Limited, Managers. Okay. I don't know what that is. That's just their, I guess, their DBA. The Honorable Court allowed a similar motion in order directed by Quincy Police Department on February 12th of 2020. The Quincy PD followed the order, but was only able to produce a limited record apparently the Norfolk DA's office received a bulk of the unedited video surveillance transported there by Trooper Fanning. And wait a minute. And he's a manager of domestic liability company expert data analysis. So that means it's not untypical for police officers to have multiple jobs because they don't get paid enough. But the fact that he is a data expert analysis corporation and he had possession, which means he would have the knowledge and the know-how to invert the videos and do all that and make it look properly verted, meaning date, time, and stamp on the bottom is correct, but the image is flipped, and he would know how to do that. Let's see. Transported there by Trooper Fanning and Colleen Crawford as Exhibit A shows the record shave paramount relevancy to factual determination, the civil action, though Fahy was at one time provided with the surveillance by the district attorney office regarding a criminal investigation into events occurring on March 23rd or 15 at the Home Tea Sports Bar. Their videos and documents were heavily edited by the sure hand of counsel for the district attorney's office. This means that the records were curated rather than raw, generating questions to accuracy. But wow, I don't have the rest. Oh, this must be the first page. I'm sorry. Commonwealth of Master Superior Supreme Court, Estate of Keith versus Paul Fay defendant. The defendant Paul Fay's motion for an order to Norfolk District Attorney's Office produce all unedited documentary and video WI-19 low records in their possession in the manner of the receiver, I guess, 2 files of events occurring at the home ice sports. Where's the rest of this? Where's the rest of this? Yeah, I got to make sure she did. Is that all you sent? There's no moss? Oh, y'all, do you know how bad this is? Angela, send this to our wonderful lawyers. Send this to Karen Reed's team. Oh my God, y'all. Do you know what that means? Do y'all know what that means? That means that right here, it states, I'll blow it up and big and again. Apparently, the Norfolk DA's office received the bulk of the unedited video surveillance that was transported there by Trooper Fanning. And Colleen Crawford, as Exhibit A, shows the record share paramount relevancy to the factual determination of the civil location. Okay. The Fayette was the one at the time provided with the surveillance by District Attorney's Office regarding a criminal investigation into the events occurring on March 23rd of 15 at the home of Tea Sports Bar. These videos and documents were heavily edited by sure hand of counsel for the District Attorney's Office. This means that the records were curated rather than raw, generating questions as to accuracy. Where's the rest of this document? Y'all. And Crawford? So you have Trooper Fanning transporting and Colleen Crawford transporting evidence or being in their hands. But Colleen and John are both real property owners and managers of the expert data analysis business. Angela. I just texted her, we're wonderful, but where's the rest? You're leaving us hanging. I'll have to make sure that I give these to Toxic. OMG. Does the shite run deep here? Oh, she just sent me back. That's all she found. Okay. I just put that's creepy, weird. So we have a history ADA for the Norfolk County of having doctored videos just a few years earlier. Oh my gosh. Okay. Well, what I'm going to do is I'm going to say farewell for now. I'm going to, why does this not go back like it's supposed to? Delete. We will come back on tomorrow. No, Sunday. Oh, we don't have anything tomorrow. I may come back on tomorrow. We'll do a document dive. But right now, Sunday night, 7:00. It's already set up. Please hit the bell. Tanika is joining us, and she's got all the new skinny on is it Daybell? My brain's fried. So come back, watch us, go click on it so you get notified. We'll be live Sunday night. Please show up and support her. I would appreciate it so very much. Thank you for everybody for your support. Elena, thank you so much for your super. I greatly appreciate it. You have no idea. And y'all have a great afternoon and evening. Tomorrow I'll try and go on live with a movie in Discord or a show. So be on the lookout for announcement. And if you have any suggestions, go over in the mod chat in my Discord, member chat, go into the member chat and give me suggestions on a movie. And I'll see if I can get it up. Until then, y'all have been a wonderful, wonderful audience. I appreciate every single one of you. Thank you so much for your love and support. And we will see you Sunday. Oh, happy day. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.